Good morning. We're on the record in case number 2021-00183, electronic application of Columbia Gas of Kentucky Incorporated for an adjustment of rates, approval of depreciation study, approval of tariff revisions, issuance of a certificate of public convenience and necessity, and other relief. My name is Kent Chandler. I'm chairman of the Kentucky Public Service Commission and will be presiding over the hearing today. Joining me today via video conferencing is Vice Chair Amy Cubbage and Commissioner Mary Ann Butler. For those in the hearing room, please set your cellular phones to silent mode or turn them off. In light of recent increases in COVID cases, we continue to take precautions, including limiting the number of persons in the hearing room, social distancing, and cleaning the witness table between witnesses. Disinfecting wipes have been placed at the witness table. We ask each witness to wipe down the area with the wipes at the conclusion of each witness's testimony. For those witnesses who will testify remotely and counsel who will participate in this hearing by video conferencing, to assist with audio clarity and to avoid feedback issues for the video hearing, please do the following. Mute your microphone and turn off your video if you are not speaking. If you use a phone for the audio and computer for video, please turn off computer audio. If you are in a room with several people on their own computers, turn off the computer audio for all but one computer. If another participant is in a nearby office, please close the doors between offices. Use wired headphones or wired earbuds. Wired is preferred because the wireless devices may lose power depending on the length of the hearing. Keep a charger nearby in case your battery runs low. And finally, and most importantly, please alert the Commission if you are experiencing technology failure that prevents your participation at any time during the proceeding. Attorneys should contact staff at the previously provided contact information. The hearing today is for the purpose of taking evidence on Columbia, Kentucky's proposed rate adjustment, depreciation study, and tariff revisions. At this time, we'll have the entry of appearance of counsel for the applicant, Columbia Gas.
Good morning, Your Honor. David Sanford with the law firm of Goss Sanford PLLC in Lexington on behalf of Columbia Gas of Kentucky. With me today is Ms. Allison Honecker, also of Goss Sanford PLLC, and Mr. Joseph Clark, who is in-house counsel for Columbia Gas.
All right, thank you, Mr. Sanford. And for the Attorney General's office? Oh, Mr. Cook, I think you're on mute.
Good morning, Your Honor. On behalf of the Attorney General, I'm Lawrence Cook.
Okay. And for intervener KIUC?
Good morning, Your Honor. Appearing on behalf of KIUC, Kurt Bain, and in this case, KIUC consists of Toyota.
Thank you, Mr. Bain.
Thanks.
And for Commission staff?
Good morning, Your Honor. Tina Frederick for Commission staff.
Thank you. I've been advised that public notice has been given and filed into the record. I believe it was filed on October the 29th. Is that right, Mr. Sanford?
Yes, Your Honor.
And my other understanding is that there are two pending motions for confidentiality. Are those the only outstanding motions?
That sounds correct, sir.
All right. At this time, no one did sign up. I believe the public notice included the information that instructions to do so would be on the Public Service Commission website. No one has signed up to provide public comments. I would just remind anybody that's watching this hearing live or after the fact that at any time prior to the case being submitted on the record, public comments may be provided to the Public Service Commission via the Public Service Commission's website, which is psc.ky.gov. Public comments can also be provided by email. You can email psc.info@ky.gov. You can also mail public comments to 211 Sauer Boulevard, Frankfort, Kentucky 40601. We ask that any public comment that you provide your name, address, and the case number, which in this matter is 2021-00183. Before we start, Mr. Sanford, is there anything that we need to take under advisement from the applicant?
Not aware of anything, Your Honor.
All right. Oh, and on the issue of stipulation, or on the issue of the stipulation that's been provided, I know there's only the two outstanding motions. Were there any motions attached to that stipulation?
No.
Okay. Is there anything we need to take from staff? Anything we need to address before we begin?
No, Your Honor.
Okay. All right, Mr. Sanford, you may call your first witness.
Thank you. I'd like to call Ms. Kimra Cole.
All right, Ms. Cole, please come to the stand. please remove your mask and raise your right hand? Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Kimra Cole, 2001 Mercer Road, Lexington, Kentucky.
Okay. Mr. Sanford, you may ask.
Thank you, Your Honor. Good morning, Ms. Cole. How are you today?
I'm good. How are you?
Good, thank you. So let's begin, just if you don't mind, by stating what your position with the company is.
Columbia Gas of Kentucky President and Chief Operating Officer.
Okay, and did you cause certain testimony and responses to data requests to be filed in the record of this case?
Yes, I did.
Do you have any changes, additions, corrections to the testimony or responses to data requests?
No, I do not.
If I were to ask you the same questions today, would your answers be the same?
Yes, they would.
Okay. Is it your desire and intent to have those responses to data requests and testimony incorporated into the record of this hearing?
Yes.
Okay, so I placed a document there on the witness stand before. Could you please identify what that document is?
Yes, this is a copy of the joint stipulation, settlement, agreement, and recommendation.
And is that the same stipulation that was filed in the record of this case on or about October 26th?
Yes, it is.
Your Honor, I'd move that we would enter that as hearing exhibit 1.
This is the document that's already filed in the record, is that correct? You just
Yes.
want it marked for purposes?
Yes.
Is there any objection?
No objection, Your Honor.
No objection.
All right, we'll mark it as such.
And then the last question for you, Ms. Cole, are there any materials that you've brought with you to the stand today?
Yes, I've brought a copy of my testimony.
Okay. With that, Your Honor, I tender the witness for cross-examination.
All right, Mr. Cook, any questions?
Chairman, the AG has no questions.
Mr. Payne?
No questions, Your Honor.
Do you have any questions, Ms. Rackman?
Yes, Your Honor, we do. Good morning.
Good morning.
As you well know, natural gas prices are higher today than they have been in the last several years. Can you give us some information about how Columbia, Kentucky has planned to deal with this increase in prices?
Yeah. We too are concerned about the natural gas prices going up. It is the commodity piece which is that is fluctuating, and we continue to look for the best options for reliable and low-cost gas to provide to our customers. But we recognize that the cost of gas going up does create concerns for some of our customers. We continue to outreach to our customers with assistance programs, our own assistance program, the Energy Assistance Program, as well as federal programs and state programs to make sure that they are aware of the assistance that is available for them if they need it to help pay their bills.
Thank you. I realize that the union contract with Columbia, Kentucky's employees is expiring November 20th, 2021. Is that correct?
That is correct.
Can you just give us an update on those negotiations?
So we spent Monday and Tuesday of this week in negotiations, and we reconvene next week to continue the negotiations. The discussion of the negotiations themselves are held confidential.
Understand that, but they are ongoing.
They are ongoing, yes.
As a post-hearing data request, I just wanted to make you aware that staff plans to ask what changes in costs in the forecasted test year were based on new union contract expectations.
Okay.
Your Honor, I have no further questions.
Vice Chair Covich, any questions?
No questions.
Commissioner Butler?
Sorry, no questions.
Good morning, Ms. Cole. How are you?
Good, how are you?
Good. I wanted to ask a question about the O&M expense. I don't think, and you may have been, well, let me just ask, were you at Columbia Gas of Kentucky during the last rate case in 2016 into 2017?
Yes, I was.
Okay. Do you case generally? Do you have any memory of that case?
Somewhat, but, haven't gone back and reviewed the case, but I am aware of the case.
Okay, and that case ended in a settlement, is that your understanding?
Yes, it did.
Okay. But even after the settlement, the commission had some concerns about particular questions that they conducted. Do you remember the commission conducting some post-hearing, a couple of rounds of post-hearing discovery and having concerns about maybe one or two additional items? Do you remember that at all generally?
I recall it generally. I wasn't involved in answering those items.
And do you remember that the concern, at least peripherally, dealt with allocation of costs from the corporate level, from the parent level of Columbia Gas?
Yes.
Okay. So in this case, Mr. Dittemore raised a similar issue in relation to O&M expense, allocated O&M expense. Is that your understanding as well?
Yes. To go back to your previous question, I think my recollection was that there was a concern that there wasn't good data to support the company 12 charges because of our system at that time, and the way we were able to collect the data wasn't in the same way that the commission would like to have seen the data.
Right. But it was surrounding, the data that you're talking about was the allocation of the expenses that are ultimately allocated to Columbia Gas of Kentucky. Is that your understanding?
Right, our corporate 12 expenses.
Okay. And the basis for, Mr. Dittemore indicated overall concern around O&M, but specifically he called out O&M that's allocated, and even some of the O&M that's allocated, but also some of the capitalized costs that are allocated from the parent level. Is that your understanding?
He made some assumptions and made some assertions on the overall level, but didn't really state what he didn't give specifics in his testimony on what the concerns were.
Right, but it was a concern based on the overall amount of O&M, including the amount that's allocated, based off benchmarking studies to other utilities. Is that your understanding?
He made some assertions about the overall level of O&M, and then he also spoke to benchmarking studies, but didn't, in my opinion, what I read, didn't really connect the two to come to a conclusion. They were kind of separate arguments that were made as part of his testimony.
Okay, so let's take a step back then. Forget Mr. Dittimore's conclusions or assertions.
Okay.
The evidence that he provided, well, it was not really evidence that he provided, it was evidence that he collated that the company provided, that the company's O&M is in the bottom quartile, at least at 2020 levels, not looking out into what changes may occur, but on a backwards-looking level, the company's O&M is in the bottom quartile. Is that your understanding?
So, yeah, he referenced a benchmark study that was used as part of our NiSource Next program to help determine where there might be some efficiencies that we could look at to act upon going forward. It really wasn't on the 2020 expenses. Those benchmarks were in the past, and we've made numerous changes since then. I believe that Suzanne Surface has explained a lot of that in her testimony.
Yeah, and I just want to make sure, you don't call into question the validity of NiSource's own benchmarking study. You would agree that it says that the O&M expenses are in the bottom quartile?
So that benchmarking study was a snapshot that really, it wasn't our own benchmarking study. It was provided by a consultant without looking at really an apples-to-apples comparison. So it was just one snapshot that was used to help identify opportunities.
I'm not saying what it should be used for. You're not calling into question the validity of your own study. It says bottom quartile, right?
So I was not involved in that study. That was just a snapshot that we have not fully vetted to see if it is an apples-to-apples comparison. So it may be that we are in the third or fourth quartile, but to just base it on that one on that one study that was provided by a consultant, I don't want to accept that as a fact.
Well, so it's your company's own study that they paid to get, that they use to inform their own overhaul. So if you can't give weight to the study, then I don't know what weight we should give to NiSource next, since that is at least an input into the, this overhaul of O&M expense. So
Yeah.
that being aside, I'll just get to brass tacks then. What study has Columbia Gas conducted to determine whether its O&M expenses are reasonable as compared to peers?
So we took the data from a benchmark study and from, comparing us to each other. There's a lot of comparisons that we do all the time through AGA. We look at what else is out there to look at opportunities. So the study you're referring to was just the very first step of doing a deeper dive to help understand where there are opportunities, both in the corporate, in the field, in business services, for opportunities. And, that was what then started the NiSource Next, which was the overall study to understand what opportunities are there and what are we going to do, and over a period of several years.
Yeah, so you all used the study that we were just talking about, the benchmarking study, to inform your decision making?
It was one piece of information that we used, yes.
Okay. So the question stands, are those measures that were taken at the NiSource level or the Columbia Gas of Kentucky level?
Those were measures at the NiSource level.
Okay, and my question is, what measures have been taken, what studies have been taken at the Columbia Gas of Kentucky level that are different or in addition to or complementary to those taken at the corporate level?
I am not aware of a study on benchmarking taken at the Columbia of Kentucky level.
What actions or measures does Columbia Gas of Kentucky take to ensure that the costs being allocated to it from NiSource are reasonable or prudent, whatever the words you want to use, whatever standard you want to use, are appropriate to be allocated?
So we have an ongoing review on a monthly basis of what are the costs that come to Columbia Gas of Kentucky from NiSource. We have several meetings throughout the month where we can discuss those charges, talk about any variances, challenge anything, and make sure that they are appropriate.
So how long have you been the head of Columbia Gas of Kentucky?
I've been in my current capacity about 2 years.
And how many times have you challenged the costs allocated by NiSource?
I ask questions about the cost frequently, just to make sure that I understand why we were charged this or why we weren't charged something so I frequently ask questions about the charges.
Yeah, I appreciate you asking questions, but you were talking about challenge. Have you challenged any of the costs that have been allocated by NiSource during that tenure?
I have not had a reason to challenge the cost.
And that during that 2-year period, it would seem that was the time period in which, for the benchmarking study, that snapshot in time, NiSource's O&M was in the bottom quartile. Did you know that was the case?
No, I did not.
Okay. And so there's and I'm going to get the exact, every company uses a different term, but there's effectively a cost allocation manual for costs to be allocated between NiSource and Columbia Gas Kentucky, right?
Right.
Okay. And are you generally aware of that agreement or manual?
I have not gone in depth to that manual. I'm aware of its existence.
Okay. And so who are you depending on to ensure, so my understanding, I've seen a few of them, probably more than I'd like to see. They mostly speak to cost categories, rather, or formula or methodologies, not to specific amounts. Is that your understanding as well?
I do not know.
Okay, well, let me ask this. Who are you depending on at Columbia Gas of Kentucky to ensure that the costs that are allocated are done in accordance with those agreements or manuals?
So I have a director of regulatory and rates that share with Ohio that provides that information. Witness who's here today, Chun Lee, she is a person that I meet with, and then Suzanne Taylor, who is also here. Those are the folks that I would ask questions to and I rely on for the appropriate allocations to be made.
Yeah, and do you know if either of those individuals are employees of Columbia Gas Kentucky or whether they're employees of NiSource or service company?
They're either Company 12 or Service Company, but I'm not sure. They are not Company 32, which is Columbia Gas of Kentucky.
Okay, so in terms of, just so I'm clear, in terms of whether or not the costs allocated to Columbia Gas Kentucky are appropriate, sort of you're depending on people who work for the places that are allocating the costs?
Yes, but it's their job responsibility to work with me and represent me in that capacity.
Okay. Are you content with the amount of identified O&M efficiencies that Columbia Gas has, the number of O&M efficiencies identified by Columbia Gas of Kentucky to date?
I think that the numbers to date that have come out of NiSource Next and through the efficiencies have been very good, and yes, I am content. Now, am I content with overall efficiencies? No, I strive every day to try to find better ways to do things, process improvements, efficiencies here locally, efficiencies corporate. So that's an ongoing process.
The efficiencies, as I understand it from the record, that are identified and reflected in the test year have been indicated to be around $4 million. Is that your understanding?
Yes, I believe so.
Okay, and do you know whether those have been identified, whether they're allocated or whether they're allocated, if they're allocated by whom, or whether they originate with Columbia Gas Kentucky? Do you know if that is in the record?
I believe it is in the record.
Okay. So, if it's not, we'll take another look, but if it's not, I think we may want to ask a post-hearing data request to specify not just the actual efficiencies, but where the efficiencies are, where in the corporate web, where they are located, and then identify whether the company, with each one of those, whether the company expects those to be ongoing or,
Yeah, and
short-lived.
yeah, I believe that most of that is in Susan Taylor's testimony, and she's here, as well as Suzanne Service.
Thank you, Ms. Cole. Mr. Sanford, do you have any redirect?
No redirect, Your Honor.
And is there any reason that this witness may not be excused?
Your Honor, only to the extent that other witnesses might possibly defer to her in any questions that we might ask, but other than that, no.
So, Ms. Cole, do you mind to stick around for a little while? I don't think this hearing should last particularly long.
Happy
So
to.
we just ask that you step down and hang around if you can.
Happy to.
Thank you.
What do you want to do with this?
Mr. Sanford, you may call your next witness.
Your Honor, we'd like to call Miss Judy Cooper, please.
All right, Ms. Cooper, please remove your mask and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
My name is Judy Cooper. My address is 2001 Mercer Road, Lexington, Kentucky.
Mr. Sanford?
Thank you, Your Honor. Good morning, Ms. Cooper. How are you today?
Good morning, I'm fine, thank you.
Would you please tell us what your title and role with the company is?
My title is Director of Regulatory Affairs for Columbia Gas of Kentucky.
Okay, and just generally speaking, what does that entail?
It means I'm responsible for regulatory filings here at the commission, including purchase gas adjustments, any sort of regulatory activity here at the commission.
Okay, and did you cause certain testimony, supplemental testimony, and responses to data requests to be filed in the record of this case?
Yes, I did.
Do you have any corrections, changes, additions, or edits to the testimony or data request responses that you've sponsored?
I do have one correction.
Okay, would you please point that out for the record?
Yes. It is on page 6 of my testimony, my original testimony that was filed with the application, line 12. The end of that line, beginning with March 2022 and continuing on line 13 through the words "and in," should be deleted. So the statement would read, Columbia's next SMRP filings will be in October 2022 for work to be performed in 2023.
Okay. And so with that one correction, are there any other changes to your testimony or responses to data requests?
No.
If I were to ask you the same questions today, would your answers be the same?
Yes.
Is it your desire and intent to incorporate your testimony, supplemental testimony, and responses to data requests into the record of this hearing?
Yes.
And did you happen to bring any materials to the witness stand with you this morning?
Yes.
Could you please identify those?
I have my testimony, data responses that I participated in the preparation of those responses, my rebuttal testimony, and a copy of the stipulation that was filed, and my testimony in support of the stipulation.
Okay, thank you. With that, Your Honor, I tender the witness for cross-examination.
Mr. Cook, do you have any questions for Ms. Cooper?
No questions, Your Honor.
Mr. Boehm?
No questions, Your Honor.
Staff counsel?
Thank you, Your Honor. Ms. Cooper, good morning.
Good morning.
I would like to begin this morning with just a couple questions about dues that Columbia, Kentucky pays to the Southern Gas Association as well as the American Gas Association. I know that the record addresses this, but I'm asking a few questions just to clarify some specifics.
Okay.
What does the American Gas Association do?
The American Gas Association obviously is an association of natural gas utilities. It does some legislative lobbying, some public relations, but most importantly, it provides a network of member communications and outreach and collective engagement so that members can discuss items of safety, reliability, customer experience issues, any sort of operational issue. It provides a forum for members at different levels of each organization to be able to reach out to their peers at other natural gas utilities and gather information, look at best practices, and it's a forum for engagement of industry peers primarily.
Thank you. Does Columbia, Kentucky incur a greater cost in paying, can I just call it AGA, American Gas Association?
Yes.
Does Columbia, Kentucky incur greater cost in paying AGA dues than it seeks to recover in rates in this proceeding?
Yes, we do contribute more in dues than we seek to recover in this proceeding. I think, did I understand you correctly?
I think you did.
Yes.
And my next question is, how did Columbia, Kentucky decide what portion to eliminate from the dues from the portion that it is now seeking recovery of?
So the portion that we seek to recover is the portion that we have determined in, I would say, with the guidance of AGA, according to IRS rulings about lobbying expenses are specifically excluded. But we have determined that the remaining amount of the dues are fair, just, and reasonable expenditures to enable our employees to network with their peers and discuss, all kinds of issues, some physical, operational issues, and some regulatory issues, community issues, best ways to communicate with customers, what we do for customers to offer assistance. Everybody's looking for best practices, and so it's that sharing of ideas. And those are the dollar amounts that we have included for recovery.
Did Columbia, Kentucky remove any amount of AGA dues for which it's seeking recovery for activities of AGA related to regulatory advocacy?
Specifically, the activities that are removed, is that what you asked me?
Yes.
Yes. So and Columbia Witness Gore might be able to provide a little more insight, but I'll tell you what I know, in that the forecasted test year amount of dues that are recovered in there are greater than what the amount that Columbia has, the amount of dues that Columbia has excluded in our 2022 forecasted test year. The expense for AGA dues that are excluded are greater than just the pure lobbying expenses as determined by the AGA and provided pursuant to IRS regulations.
Were any amounts excluded because they were related to public relations activity of AGA?
And a specific identifiable amount has been excluded from our request for recovery, and that amount is deemed to cover lobbying expense and regulatory lobbying expense, as well as legislative and public relations. Those are the activities that, from past history of the commission, we understand are not eligible for recovery.
As far as a dollar amount, what is the dollar amount that was removed because of AGA's engagement in regulatory advocacy?
I will ask Mr. Gore to respond to that.
Okay. And if I asked you what specific dollar amount was removed for public relations, would Mr. Gore be the witness to answer that question as well?
Yes.
Okay, thank you. And what is Columbia, Kentucky's basis for alleging that the expense that Columbia, Kentucky incurs maintaining membership in AGA benefits Columbia, Kentucky's customers?
The benefits that we are able to gather from the networking with our peers inures to the benefits of our customers in service, reliability, and cost.
Thanks. Now let's move on to the Southern Gas Association, and we'll refer to that as SGA.
Okay.
What does the Southern Gas Association do, and if it is different from AGA, can you explain how?
The Southern Gas Association provides more hands-on training, I would say, and education in operator qualification areas. So that's their niche is really more training more closely related to the field, and in fact, for employees that are out in the field. They do some general business service, networking opportunities that are provided there, and certainly that's a way that employees can become connected, but most of their training is, in my viewpoint, geared to field employees and technical training.
Thank you. Does SGA engage in legislative advocacy of any type?
No, they do not.
What about regulatory advocacy?
No, they do not.
What about public relations?
No, they do not.
Does Columbia and Kentucky incur greater expense paying SGA dues than it seeks to recover in rates in this proceeding?
I believe, I'm going to ask if you wouldn't mind, ask Mr. Gore that.
Okay.
Yeah. He can be more precise.
Okay, thank you. So if we were to ask about any portions that might have been removed and why, that would be Mr. Gore's territory, correct?
The amounts would
The
be
amounts.
Mr. Gore's,
Okay.
yes.
All right. And similar question, but because they're different organizations, I'm going to ask it again. What is Columbia, Kentucky's basis for alleging that the expense that it incurs remaining paying its dues membership to SGA has a benefit to Columbia, Kentucky's customers?
The benefit is in the training and the expertise that they provide to our employees that allows them to provide safe, reliable, and as more efficient service, as efficient as possible. We're always looking for continuous improvement. So the sharing of ideas goes to the benefit of the customer.
How often in, say, a year's time would Columbia, Kentucky employees attend a training that was sponsored or put on by SGA?
I don't know that. I know they offer a lot of training. I don't know how often. that
Does
would be.
Columbia, Kentucky have a policy of mandating that its employees attend trainings offered by SGA?
Not to my knowledge.
Okay, is there another witness that could answer that question?
Maybe Mr. Roy?
Okay. All right, now, let's turn to the issue of credit card fees.
Okay.
Is Columbia, Kentucky aware of any studies that tie the payment of utility bills by credit card to a net decrease in uncollectibles or bad debt expense?
Any studies that tie the payment by credit cards to a decrease in bad debt expense? No, I'm not aware of any study of that type.
Does Columbia, Kentucky have any evidence at all in-house that would indicate that including credit card fees in base rates for Columbia, Kentucky's customers has an effect of decreasing bad debt?
I don't believe we have any studies about credit card fees decreasing bad debt. We have studies that customers desire to pay by credit card if the credit card fees were removed. Right now, if a customer pays with a credit card, goes through a third-party vendor, and there is a credit card fee that's charged to the individual customer that chooses to pay by credit card. We do accept credit cards, but the fee is paid by the individual customer. The customer experience data that is provided, and some of that comes from J.D. Powers, which is a national consumer satisfaction ranking business, that they repeatedly tell us each year that our customers would be happier if they didn't have to pay the credit card fee. So we did include an adjustment to absorb those fees in our application. In our settlement, we agreed to, knowing commission precedent, remove those fees, and so the practice would continue as it is today.
And we're gonna move on to Columbia, Kentucky's seasonal reconnect charge. What is the basis for charging a seasonal reconnect charge?
That fee originated because we were experiencing, and it goes back some years, I can't recall what year that first entered into the tariff, but it's been some few cases ago. And the basis was that customers were calling, asking us to shut their gas off for the summer or some period of time, and then calling us to go back out and reconnect the gas. And of course, every time that a customer requests service be discontinued and then reestablish service, it requires an employee to go out there and physically disconnect the service. Then to reinstate the service, it requires safety checks and reestablishment of service. So it cannot be done remotely. And so the intent was that it was a carrot or a stick, however you might want to look at it, but it was an enticement for customers to have them remain on service through whatever period of 3 months or whatever period of time they might have wanted to disconnect service otherwise. So we would avoid the additional cost that would occur from the need for employees and having employees go out and make those kind of service trips, which, that could interfere with emergency response.
Okay. What is the relationship between the cost to reconnect the service after a seasonal disconnect and the minimum monthly charge?
That has not been studied.
I believe, according to Columbia, Kentucky's response to staff's second request, item 50B, that the seasonal reconnect charge is equal to about 8 months worth of minimum monthly charges.
It is exactly that. That's how it was designed, that it's 8 months times the minimum monthly charge.
So why 8 months? Why was the 8-month figure used?
Gosh. I don't remember. I would have to say that I don't remember. It was designed as a carrot or a stick. As I said, it was designed as an incentive or an enticement for people to remain on service, and it was in essence something to encourage behavior and encourage behavior by remaining on service. So it was. I really don't remember how 8 months was determined as opposed to some other number of months.
Okay. Now, this question is going to concern late payment fees and utility assistance programs. What period of time is a late payment charge not assessed when someone is on a utility assistance program?
So a utility assistance program, I need a little bit of clarification. What do you mean?
Some
There's a
program
number of
designed to
kinds.
help low-income utility customers pay their bills.
Okay, so just generally, if a customer is on our energy assistance program, or if, I'm understanding by the nature of your question, it to mean more broadly, if someone is, has reached out for assistance and they have a promise of payment, is that what you
Yes.
mean?
Yes.
I'm trying to
Yes.
make sure I understand so I can answer correctly.
Yes.
Although the answer's the same, really. But I just want to make sure I'm answering what you're asking me. But when a customer is receiving energy assistance, there are no late payment penalties assessed.
Does that include a customer that has a pledge or some sort of a letter notice that they're going to be receiving this energy assistance?
Yes, it does. As soon as we get any kind of notification that assistance is coming, a credit delay is put on the account. There are no late payment charges. There are no collection efforts until that letter of assistance or promise of assistance is paid. There's no further action for collection taken on the customer's account.
Okay, thank you. You answered my question.
Okay.
I appreciate that.
Sorry.
And I have a question about bills, paper bills as well as online bill statements, and how the gas supply cost appears on the customer bills. And I ask this question because the commission staff recently took a telephone call from a customer. And although staff was asking him questions about his bill and the specific line items and having him read the bill, they didn't actually have a copy of the bill to look at. It became kind of, it appeared from the way he was reciting his bill that the gas supply cost was not on the bill that he was reading from. But we do notice that online bills do show a gas supply cost, and the sample bill on file with Kentucky's tariff shows gas supply cost. So can you confirm for the record that the gas supply cost is listed as a distinct item on both the paper bills that are mailed out as well as the online bill statements?
Yes, I get a paper bill myself, and it's on the second page. It's not on the front page. It's on the second page on the back. But yes, the gas supply cost is listed there.
Thank you. Your Honor, I have no further questions for this witness.
Vice Chair, do you have any questions?
No questions.
Commissioner Butler?
Sorry, no questions.
I have a couple. The first is around the AGA and SGA dues. Just so I'm clear, the actual adjustments that were made by the company, those should be asked to a different witness Gore. Is that correct?
The actual amount, yes, the actual amount should go to Mr. Gore.
Okay. Seasonal reconnect. I don't know if it's a carrot or a stick. It appears to me it's just a way for the company to be indifferent as to whether or not a person disconnects for the season or reconnects, right? You've been at Columbia for 20 years, let's just call it around 20 years, is that right?
That's right.
Okay, and then you were at the commission before that,
Yes,
correct?
I
Okay,
was.
so you've got a good amount of experience dealing with not just Columbia's rate design and everything, but other utilities even before you went to Columbia, correct?
Yes.
Has there been a change well, let me just ask this. Have customer charges, monthly customer charges been increasing over the time, let's just say since you started the Public Service Commission?
Yes, everything has increased.
Everything has been increasing.
How many years did you add that up yes, everything.
I'm not going to say for the record. But let me just ask. When you started doing this, was it uncommon for customer charges to be a couple of dollars, $2, $3, $4, for electric or gas customers each month?
Gosh, I really don't remember. They were certainly less than they are today. I don't know what they were back when I started out. I started out in water and sewer.
Yeah, the minimum bills, right? Yeah.
Yes.
Do you think that there's any correlation to the fact that, well, let me ask this, seasonal disconnects, 8 months was what you agreed that the basis for the charge was, the reconnect charge. That you go 8 months, you make the reconnect be 8 months. It just seems to me that that's fairly reflective of assuming a person has gas heating, uses the gas for 4 months, and then would maybe disconnect until the next gas season. Is that generally your understanding of the basis for that 8-month calculation?
Seems rational to me, yes.
And so effectively, a person might disconnect that service because they don't need the gas. They're not taking service, correct?
Yes.
And so the reconnect fee either says you're going to take the service through the whole 8 months, through the entire year, and pay that customer charge, even though you're not taking any gas, or you're going to pay the exact same amount even though you didn't receive service for those 8 months. Is that correct?
That's the theory, yes.
Okay. And the only benefit that I can think of, and we'll see if you agree, would you agree that the only benefit to a person, the mindset of disconnecting for those 8 months, is that they don't need the service, and so they don't want to pay that monthly fee that comes with being connected? Would you agree?
I don't know what somebody would think. Yeah, I wouldn't venture to guess.
What monetary benefit would they get?
What monetary
Yeah.
benefit?
What economic benefit would a customer who seeks to disconnect for 8 months, only to reconnect, assuming there's no seasonal reconnect fee, what economic benefit would they receive?
If they chose to disconnect, I'm making sure I got all your questions. And they chose to disconnect for a period of time, and then they called back to reconnect at some point in time. So they have avoided any charges during that period of time. But when they call back to reestablish service, they would then, in theory, be assessed the seasonal disconnect fee. So they would have been indifferent at that point.
Well, the company would certainly be indifferent, right? They're either going to make 8 months of customer charges, actually charge to the customer, or they're going to make 8 months worth in the reconnect fee.
Right.
Under the current proposal. But if there was no seasonal reconnect, effectively the economic benefit to the customer is not paying the customer charge those 8 months, correct?
Right, and this is not a new proposal, that the theory was put in place. I don't recall what year that, or in what case that originated. But mechanically, it was designed as 8 times the customer charge, and so that's why it changes this time. So it's not a new proposal. The amount is just changing.
And the company's proposal for the customer charge is what, approximately $20, is that correct?
In our application,
In the stipulation.
in the stipulation, it's $19.75.
$19.75.
Yes.
And so we're talking about $155, right? Almost $160.
Yeah, well, 20 times 8 would be 160, so it would be a little less than that, but yeah.
158. So
Okay,
we're talking $158. If a customer charge was $5, we're not talking about $158 anymore, right?
Then we'd be talking about $40,
$40.
8 times 5.
if there was no customer charge, and all costs were recovered through a volumetric charge based on how much somebody used, we'll just talk about residential customers, just residential. Based off what somebody used, the company would still be indifferent whether or not a person used for 4 months or 8 months. The billing determinants would only be volumetric. Isn't that correct?
Well, we would not be indifferent, certainly, because all of, the majority of our costs are fixed in nature, more so than variable in nature. So the purpose of a rate design that is composed of fixed and volumetric rates is, in theory, a utility would prefer that most of its fixed costs are recovered through a fixed recovery mode, and variable costs are recovered on a volumetric basis. So that's the theory. It doesn't hold 100% true. The art of rate design is a company would always strive to have that matching. But to go on a pure volumetric basis is not something the company would be indifferent to.
Well, I mean, as long as the billing determinants are the same every year, the company would be different, would be indifferent.
That doesn't take into account weather or changes in consumer behavior.
Certainly. I'm making a simplifying assumption to say that the problem that this 8-month basis for the seasonal reconnect seems to be the fact that the customer charge continues to increase and customers are looking to ensure that they aren't charged costs when they're not taking service. And so they choose not to take service for 8 months. But this proposal makes the company indifferent. Whether you stay connected for 8 months or reconnect 8 months later, we're still going to recover that customer charge, right?
That is the theory, yes.
Do you think there's a correlation between the number of customers that, I mean, you certainly have experience in this. Do you think it's reasonable to believe that there's a correlation between the number of customers interested in disconnecting in non-heating times of the year and the fact that the company's proposals to increase customer charges have gone up in each rate case?
Can you say that one more time?
Yeah, do you think if the customer charge was $2, I'm going to withdraw that question. If the customer charge was $2, do you think that there would be as many people wanting to disconnect in non-heating times of the year as if the customer charge was $19.75?
I see what you're asking, and my perspective, if I were given that equation and knew that it was going to be $2 or $19, I mean, yeah, certainly, I mean, $2 is a lot less than $19, and I might give up $2 a month, but not $20 a month. But I don't know that the impetus to disconnect service is driven by the customer charge for the majority of our customers.
Well, so let me ask this way. We talked earlier about the economic benefit of disconnecting absent the seasonal reconnect charge. If it's not for economic benefit, by avoiding the customer charge, what do you think would lead somebody to want to disconnect only then to reconnect seasonally?
I can't imagine why. I mean, why would you want to go through the trouble and then you have to have somebody come out to your house and disconnect, and then they have to come back and reconnect? I personally would not want to be bothered like that and have to remember that my gas was turned off and it got cold like last night, and my husband turned the furnace on last night. I guess it's November. I mean, but if your gas was turned off and it suddenly got cold, you're not going to be able to flip the switch and have your heat turned back on.
But you might for $158.
But you might, yeah,
Um,
you might. And I'll just say, you mentioned my experience. My experience tells me we don't see that as commonly today as years ago in the past.
Well,
Now,
but-
whether that's because of the seasonal disconnect fee, I don't know if that has had the intended effect on behavior. But we don't have the same, I haven't looked at any actual numbers, but this just anecdotally.
Well, now that the economic benefit isn't there to do it, maybe there's just less people doing it. Maybe there wasn't any other reasons, right?
Yeah, I don't know.
One of the items you mentioned in your responses to staff council, you talked about the cost to actually go back and reconnect these folks, right? To go back, and you can't do remote disconnect's one thing, remote reconnect is another, right?
We don't do that.
It's not safe to do it for gas, certainly. You don't know what's happened to that meter set since it was disconnected, pilot light issues, right? Completely understand that there are additional efforts that have to be taken in order to reconnect somebody. Would you agree that the current seasonal reconnect fee is not based off of any of those expenses?
The reconnect fee itself, when it was, reconnect fee, yes, yes, I would agree. It's based off of the customer charge.
Mr. Sanford, do you have any redirect?
Just a couple, Your Honor, if I may. Ms. Cooper, let's just kind of continue to talk a little bit about this seasonal reconnect charge. That would be classified as a non-recurring charge, correct?
Yes.
Okay. And so can you give us a sense of maybe the magnitude, what, and you may not know, but what percentage of customers engage in that type of behavior where they'll disconnect for the summer months and then ask to be reconnected for the winter months?
I don't know the percentage of customers, but I believe Mr. Johnson would know. Well, I don't even know if he would know right now the dollar amounts. They would be miscellaneous revenues.
Okay. Would it be fair to say that it's a relatively small number of customers?
Yes.
And I think I heard you say earlier, but I want to make sure I understood correctly, that it's declined over time in recent years?
I don't have hard numbers, but that's my perception.
Okay. So, from a general rate-making point of view, whenever you have revenue that's derived from a non-recurring charge, how is that applied to a utility's revenue requirement in a rate case?
So those revenues are contributing to the overall revenue requirement through the collection of that charge. Again, I don't know the actual amount, but I think that would be in Mr. Johnson's revenue numbers to show how much is included as miscellaneous revenue there. And if it were not collected through that seasonal disconnect charge or reconnect charge, whatever type of non-recurring charge it might be, which right now it goes to reduce the overall revenue requirement that's spread over the customer charge, fixed and variable rates, then that amount would need to shift and be recovered through the whole customer base through the fixed and variable charges.
Okay, and so if there's any downward adjustment in this particular or any type of non-recurring charge in that revenue, then it needs to be offset by an increase in the base rate? Did I hear you say that
Yes.
correctly?
Yes,
Okay.
that's right.
So is there when Columbia makes an investment to be able to provide service to a customer, that's largely a fixed investment, correct?
Yes.
And
Installation
so-
of the pipe.
And I thought I heard, but just to confirm, one of the goals of a customer charge is to recover a portion of those fixed costs on a monthly basis regardless of a customer's usage, correct?
Right, because whether a customer uses any gas or not in the summertime, the pipes are still there, the meter is still there. Our folks are prepared to respond to any emergency if they think they smell gas in their front yard or somebody else's front yard, and still performing customer communications and billing. So
Okay.
those are fixed things.
So from a customer's point of view, if they disconnect their gas service for a period of 8 months or up to 8 months, then they're avoiding paying certain fixed costs of the utility, correct?
Yes, they are. I don't know if they know that or not.
Okay.
They know they're avoiding paying a monthly charge.
And so ultimately, that ends up going to the utilities margins, impacts returns. It has a more profound impact than just them avoiding that monthly charge.
Oh, it certainly impacts the company, yes.
Okay, and so when the utility comes to the next case, does that incrementally lost revenue, does that have to be recovered somewhere else through higher rates?
It falls to the broad base of customers who are, yes,
Okay.
maintaining service.
So is part of the theory behind the seasonal disconnection rate a deterrent to prevent some customers from, in essence, free riding at the expense of other customers?
Yes, you said that, yes, that's right.
Okay. Your Honor, that's all the redirect that I have.
Is that a technical term, Mr. Sanford, free riding?
I believe that it is.
Okay. Ms. Cooper, it's my understanding, and you've not asked for this, Mr. Sanford, but the documents you provided staff earlier indicated you'd like to recall or have the opportunity to recall Ms. Cooper, is that correct?
Yes, just based upon the purview of her expertise, we anticipate there may be some questions that would be referred to her later.
Okay, that'd be fine. So we just asked Ms. Cooper that you, as you step down, that you stick around, you and Ms. Cole stick around for a little while since somebody may be kicking things to you.
Okay,
Thank you.
thank you.
So it's my understanding, counsel, and Mr. Cook, that there's an agreement amongst the parties that we take a break from the company's case and move to Mr. Bodino's. Is that right, Mr. Sanford?
Yes, we were trying to accommodate. I think he's double booked today.
Are you prepared, Mr. Cook? It's 10:15. We usually wait a little longer before break. That this may be a good time to take Mr. Bodino, given his, I think, our orders on this and the concern for scheduling.
Yes, Chairman, I believe we are ready to proceed. I see that Mr. Bodino is ready.
Are you prepared, Frederick?
Yes, Your Honor.
All right, Mr. Cook, you may call your witness.
Okay, we call Richard Bodino.
All right, Mr. Bodino, please turn on your camera, turn on your microphone, and raise your right hand. Do you swear or affirm that the testimony you are about to give is true and correct under penalty of perjury?
Yes, I do.
Okay. Please state your name and address for the record.
Yes, my name is Richard Bodino. My business address is J. Kennedy and Associates Incorporated, 570 Colonial Park Drive, Suite 305, Roswell, Georgia.
Mr. Cook?
Thank you, Chairman. Good morning, Mr. Bodino.
Good morning.
Are you the same Mr. Bodino, Mr. Richard Bodino, that caused direct testimony to be filed into the record of this matter under your name?
Yes.
Okay. Did you also respond to certain data requests of the Public Service Commission staff and of Columbia Gas?
Yes, I did.
And do you have any changes or additions to make to your testimony or to those responses?
No, I do not.
Okay. And if I were to ask you the same questions today, would your responses be the same?
Yes, they would.
Your Honor, we tender the witness for cross.
Mr. Sanford, do you have any questions, Mr.
Just
Bodino?
two very brief questions. Good morning, Mr. Bodino. First off, if you had a chance to review the stipulation and settlement agreement that was filed in this case,
Yes, I did.
And just based upon your perspective in its totality, do you believe it to be a fair, just, and reasonable outcome?
Yes, I do.
Thank you, Your Honor. That's all the questions we have for this witness.
Frame?
No questions, Your Honor.
Ms. Frederick, any questions?
No questions, Your Honor.
Vice Chair, any questions?
No questions.
Commissioner Butler?
No questions.
All right. I have just a very few, Mr. Bodino, and you should trust me this time when I say that. So you employed two methodologies for your ROE recommendation, is that correct?
Yes, sir, it is.
Okay. And that's the DCF and the CAPM, right?
That's right.
And it's not the empirical version of the CAPM, it's the good old-fashioned 60-something-year-old version of the CAPM, right?
That's right.
Okay. Would you agree that the CAPM and the DCF are fundamentally different in the way that they determine ROE estimates?
Well, they are, yes.
Yeah. And the DCF is a valuation methodology?
Well, yes. I mean, it uses the, in this case, the stock prices from the companies in the proxy group as a direct input to determining what the investor required return would be.
Okay. And it does that by looking or estimating future cash flows based off of, it does that by looking at cash flows based off of an estimation of what the cash flows are going to be ordinarily relative to what the expected cash flows are now, correct?
Well, that's right, yes.
Okay. And the way, particularly that you do your DCF, those cash flows, it's not necessarily the firm's cash flows, it's the dividend. Is that correct?
Well, it is. Yeah, of course, the assumption, one of the assumptions in the DCF is that dividends and earnings grow at the same rate over time, but really how we measure the cash flows would be dividends.
So you're aware of, and I'm sure you are because I believe you cite them in your testimony, the Hope case under the Federal Natural Gas Act, just and reasonable standard, as well as the Bluefield case, correct?
That's right.
Okay. Now, when you think of the DCF, I was asking you the sort of leading questions, and you were also giving me the answers. Nowhere in there was a discussion of risk, right? That there's a portion of the methodology that takes into consideration the risk. So is the assumption of risk is that when you look at what the stock price is relative to cash flows, that investors have effectively imputed the risk into what they're willing to pay or hold the stock at?
Well, yes, that's sort of one of the assumptions there. They have looked at, and essentially you would say the risk of receiving those cash flows over time, and so that reflects in what they're willing to pay for that stock.
Okay, but it's not a definitive amount. It's not an identifiable amount in that methodology to determine risk, right? It just shows up in the ultimate price that's calculated using the methodology.
Yes, that's right.
Okay. Comparing that to the CAPM, well, let me take a step back. Going off risk, would you agree that the Hope standard specifically discussed the idea of, or the reality of, at least under the just and reasonable standard of the Natural Gas Act, that, and I'll just read it frankly, 603 of the Supreme Court site, by that standard, the return to the equity owner should be commensurate with returns on investments and other enterprises having corresponding risks. Is that your understanding of what Hope says? Yes,
that's my sort of layperson, non-lawyer understanding of it.
Right. The person, I think it's always funny with these, we circle on the legal standard and then we give it to economists and financial people to try to implement the legal standard, and then they get asked about the legal standard. I guess what I'm going to ask about the CAPM is there a more discernible inclusion of risk in the CAPM methodology than in the DCF methodology?
More discernible.
Yeah, so is risk specifically taken into account in the CAPM methodology?
Well, I think you could say that because of the use of beta, and the beta is a measure of risk as applied to the overall measure of market returns. So in that sense, you do have, I guess you could say, a more explicit variable for risk, and that variable would be beta.
Yeah, and so in the CAPM, beta represents the relative risk of an individual stock as it relates to an overall market return, correct?
Right.
And the risk in that context is sort of a deviation from expected returns, and the expected return is the market return, correct?
Yes, return relative to the market return, and of course beta would be the measure of how much that differential is.
So with that being the case, do you ever have concern that the fact that the DCF implicitly takes into account the risk that the Supreme Court has required in Hope to be reflected, whereas the CAPM explicitly takes into account risk?
I don't have any concern about that. I think one of the things that we would try to look at is the other risk measures to see if we've got a proxy group, for example, that Mr. Ray and I have used in this case. Is the results we get from the proxy group for the DCF, for example, would those be roughly comparable to the utility in question to which we would apply that number, and this would be Columbia Gas. And I think Mr. Ray and I have discussed those other measures. You can look at those as possible firm size, credit ratings, and so forth.
But that would be the same with the CAPM and the use of a proxy group, correct?
Oh, yes, definitely.
Okay. So why is it that you prefer the DCF over the CAPM?
I think it's first of all, the DCF is a valuation methodology that goes right to the valuation of the companies in the stock market, and it is a very clear in terms of the stock price. That's a clear indication of the preference of investors to hold that stock. In that way, I think it's more of a direct method of estimating the investor required return. With respect to the CAPM, as I mentioned in my testimony, there are questions about the accuracy of beta, and there are also a lot of questions about how you actually measure that market return, and how you measure that market return can result in very wide estimates, if you will, of not only the market return, but of the CAPM result that would be applied to the subject utility.
Yeah, and that's the market risk premium that you're discussing?
Right, and how you measure that, the market return.
Yeah. And in terms of beta, you were saying, is it that what betas to use, whether you go back 50 years, 10 years, or use a forecasted or expected beta, is that what you're saying, it's not that it can significantly change based off those data sets, depending on which one you use?
It could do, and whether you use 2 years, 5 years, or 10 years, that can certainly affect the calculation result of beta, but can also raise a question as to whether that is the correct beta that investors are looking forward to, and how they're using beta to value that stock. So we kind of rely on history, whether 2 or 5 year price changes relative to the market, excuse me, to quantify beta, and we sort of assume that those historical numbers are what investors expect for the future.
So my final question on this front, and I think you kind of maybe accidentally mentioned a portion of it. Should consideration be given to what methodologies or the calculations used by actual shareholders to determine their own demands. Should there be consideration of that in determining returns on equity for regulated utilities?
If I understand your question, I believe we do have given consideration to that. I think it's reasonable to assume investors would use the DCF and the CAPM. I think the CAPM is more accurate, certainly, and it's widely used, so that's the one I prefer. And Mr. Ria, in his analysis, although I disagree with his recommendation, I believe he's tried to use what he considers to be the methods that investors would use to determine their required returns.
Yeah, so do you know if there's a prevailing methodology that's used, for finance or MBA students that they're taught, whether they come out of school going into private equity or wherever they may go, whether they're walking into that with knowledge of primarily the CAPM or the DCF, one over the other?
I don't know if there's a prevailing methodology. I don't know the answer to that.
Okay. Those are all the questions I have for Mr. Bodino. Mr. Cook, do you have any redirect of the witness?
No redirect, Your Honor.
Okay. And is there any reason, Mr. Sanford, Ms. Frederick, that Mr. Bodino can't be excused for the remainder of the hearing?
No, Your Honor.
No, Your Honor.
All right. Thank you for being here with us, Mr. Bodino. Safe travels on your way to your other destinations.
Thank you very much, and I really appreciate the commission and the company accommodating my travel schedule today.
Of course. All right, Mr. Sanford, we've gotten through three. How about we take a 10-minute recess until 10:40, and we'll come back and let you call your next witness.
Sounds good, thank you.
We're back on the record in case number 2021-00183, Columbia Gas of Kentucky. Mr. Sanford, do you have an additional witness you'd like to call?
Yes, Your Honor, we'd like to call Mr. Vincent Ray up, please.
Okay. Mr. Ray, please raise your right hand and remove your mask. You can place it back on after you do this. Do you swear or affirm that the testimony you're about to provide is true and correct under penalty of perjury?
I do.
Okay, please state your name and address for the record.
It's Vincent V. Ray. My address is 80 Blake Boulevard, Pinehurst, North Carolina.
Okay. Mr. Sanford, you may ask.
Thank you, Your Honor. Good morning, Mr. Ray. How are you today?
Good. Good morning.
And would you mind to just state your employer and your title for the record, please?
My employer is Regulatory Finance Associates, LLC, and I am the managing director of that company.
And did you cause certain testimony and responses to data requests to be filed in the record of this case?
I did.
Did you have any changes, edits, corrections, deletions to that responses to data request or testimony?
No, I do not.
If I were to ask you the same questions today, would your answers be the same?
Yes, they would.
Is it your desire and intent to have those responses and testimony incorporated into the record of this hearing?
Yes, it is.
Did you happen to bring any materials with you to the witness stand today?
Yes, I have a binder which has my direct testimony, my rebuttal testimony, and the company's responses to multiple interrogatories or data requests.
Thank you, Your Honor. I'd tender the witness for cross-examination.
Mr. Cook, do you have any questions? Mr. Cook, are you there? All right. Mr. Bain,
No questions, Your Honor.
staff counsel?
Thank you, Your Honor. Mr. Leach is helping us. He's going to display some documents if we need to have anything displayed for the witness. So, Mr. Leach, right now, if you could turn to Mr. Ray's rebuttal testimony. This is on PDF, page 96. I think the page number is 74, but it's page 96 of the PDF. We're looking at a table. I'll give him a minute to get that up. There we are. Thank you very much, Mr. Leach. Now, Mr. Ray, this table, according to your testimony, reflects the average equity capitalization ratio adopted by the Commission for Gas Utilities between the years 2018 and 2021. But the listed cases are all for years 2017, 2018, and 2019. All of the final orders in these cases were issued in either 2018 or 2019. Can you just explain to us why the results for the LG&E rate cases 2018-00295 and 2020-00350 were excluded from your analysis presented on this table?
Any other outcomes with regard to equity capitalization, if they've occurred since that time, they should have been included in this table. So we did focus here on gas utilities, so to the extent that there has been outcomes since the time that this table, or beyond the dates that are presented within this table, if it's a gas utility, and if it was explicitly stated within the final order, it should be in this table. And I have cited the outcome in the LG&A case in my rebuttal testimony. I could turn to that. It's within the first, I think, 4 or 5 pages of my rebuttal testimony.
Okay, so specifically, why were the rate case from 2018 and the rate case for 2020 for LG&E excluded from this?
I don't think it was done intentionally. It was, let me, if I could have just a moment, please. I'd like to go back to the first couple of pages of my rebuttal here. Okay, so I did find it, it's page 9 of my rebuttal testimony. The level of equity capitalization in the LG&E case, as I've cited it here on page 9 of my rebuttal testimony, was 53.19%, which is actually higher than what the company has requested in this proceeding. But to your point, yes, that should have been included in the table.
Okay, thank you very much. I have some additional questions about this table. Case 2019-383 and 2018-341. Those are for Columbia's AMRP, and that's a specific rider, not an entire rate case. Is that correct?
That is correct, yes.
And why did you compare the capital structures between a rider case and a full rate case?
Well, I think they're just points of reference. So to the extent that ultimately a commission order assigns a different, equity capitalization or ROE, that certainly occurs, but I think in this case, we're just trying to accumulate as many possible data points as we could find, because quite honestly, those data points were few and far between. They were difficult to find, so we wanted to present the available information that we did find.
Okay. And why did you not include Atmos's capital ratios for its pipeline replacement program? Those cases are excluded as well from this table.
What I could say is that we pull this information from Regulatory Finance Associates, Regulatory Research Associates, which is now part of S&P Global, and these were the outcomes that we found in that report. So we weren't explicitly excluding any particular outcome. These were just the available outcomes that we found in the report that we ran on S&P Global.
So if I were to ask you why the cases involving LG&E's gas line tracker cases during this time period were not included, your answer would be the same as what you just provided for Atmos?
Right, and I would just add to that I thought that in the case of this particular table that we did want to include Columbia Gas of Kentucky's AMRP outcomes because they were more germane to the company. So generally speaking, we would just include within a graph like this outcomes with regard to general rate case outcomes. But in this case, because we did see these outcomes for the AMRP program, we thought that they were germane to this proceeding.
Okay, thank you. And the capital ratio applied to Columbia's AMRP cases, I think now known as SMRP, is the same as that approved from Columbia, Kentucky's last rate case, which was 2016-00162. Do you believe it's appropriate to account for it twice?
Now, when you say account for it twice, are you saying within this average value on this chart?
The capital ratio applied in the AMRP cases, yes.
Well, I mean, they were two separate outcomes, so in 2 different years. So yes, I think it would be appropriate from the standpoint that they were different orders, yes.
Thank you. I have no further questions for this witness.
Vice Chair Kovich?
No questions.
Commissioner Butler? Okay. So I have to follow up on staff's questions. If there's a settlement in a case and it says that the return on equity and capital structure approved in that case shall apply moving forward for riders, do you think it's then appropriate to use each one of those rider filings for the purposes of something like this to average it out?
I understand your point. If, to the extent that there was a single order that continued on in time, I think it is a valid point. Although I don't think it would materially change the outcome in terms of this table.
Right. It reminds me of Vetco or Dominion's 11.8%, I believe, ROE that they got approved something like a decade ago. It stays in place, but then all the new capital they're spending is subject to additional riders. Are you aware of that situation?
No, not in particular.
I guess Atmos here is an outlier. Would you agree?
Yes.
And it's that 2018 amount that's the outlier. Are you aware of whether the commission expressed concern with that equity ratio?
I would imagine that they did, but I do not know that for certain.
Right. But to use, well, let me just ask, other than that amount, would you agree that the Columbia, Kentucky proposed equity ratio is higher than all the other data points?
No, I mean, I've just cited to the LG&E case, which was in the 53% range.
But that's not what you used on this table. I'm saying for purposes of calculating this average for comparison, you chose a data set, right? And for the average, you're showing that Columbia, Kentucky's is below the average. But effectively, the only data point included in this average that's actually higher than Columbia is the Atmos 2018 matter, right?
That's correct.
So what was the purpose of this table?
It was just generally to show that in response to Mr. Bodino's proposal that the equity capitalization be changed in this proceeding, be lowered based on the offset from the change in the short-term debt ratio that he proposed, that the company's equity capitalization as proposed in this proceeding at 52.64% is very reasonable based upon recent outcomes within Kentucky.
But it's higher than every one of these other than Atmos. At Atmos, the commission expressed concern with the equity ratio.
I would agree with that statement, but I would also give the caveat that the 2017 proceeding that you see there in the second line item is very similar at 52.57% to what the company has proposed in this proceeding.
All right, Mr. Sanford, do you have any redirect of the witness?
No, Your Honor.
Okay. Is there any reason this witness cannot be excused?
No, Your Honor.
Thank you, Mr. Ray. You may step down and be excused.
Thank you.
We'll take just a second, Mr. Sanford, to give Mr. Ray time to take care of the witness box before you call your next witness. It's your pleasure, Mr. Sanford.
Thank you. We'd like to call Mr. Jeffrey Gore to the stand, please.
Mr. Gore? Mr. Gore, I ask if you remove your mask and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Jeffrey T. Gore. My address is 290 West Nationwide Boulevard, Columbus, Ohio 43215.
Mr. Sanford?
Thank you, Your Honor. Good morning, Mr. Gore. How are you today?
Just fine, thanks.
Would you mind to state what your position is and by whom you're employed?
I'm employed by NiSource Corporate Services, which is the service company for NiSource, and my title is Regulatory Manager.
And did you cause certain testimony and responses to data requests to be filed in the record of this case?
Yes, I did.
Do you have any changes, edits, corrections, or deletions to the testimony or data request responses?
Yes, I have two.
Can you point those out, please?
Yes, thank you. Data request AG1208. I have identified a clerical error where we have incorrect calendar year dates. Reading across the page in the response to number A, we have 2018 calendar year listed 6 times. The first 2 should be 2018, the second 2 should be 2019, and the third 2 should be 2020. Secondly, is kind of a combination in my response to AG Set 1, number 27, I actually stated a correction to my originally filed testimony. And I can just read for the record the first sentence or two of that to explain that. The statement in Gore testimony, page 14, line 16, paren, as of February 28, 2001, the account balance in account 252 is zero, should have been, as of February 28, 2021, the balance in account 252 with 5 zeros is offset by the balance in account 186,00400.
Okay, so with those two corrections, if I were to ask you the same questions today, would your answers be the same?
Yes, they would.
Is it your desire and intent to have your testimony and your responses to data requests incorporated into the record of today's hearing?
Yes.
Did you happen to bring any materials with you to the stand this morning?
I have a binder that has my original testimony, my rebuttal testimony, and a lot of the data requests that were answered.
Thank you, Your Honor. With that, I'll tender the witness for cross-examination.
Mr. Cook, you there?
The AG has no questions, Your Honor.
Okay.
No questions, Your Honor.
Ms. Frederick?
Thank you, Your Honor. Mr. Gore, there were some questions that were asked earlier of Ms. Cooper, and she said that you would probably be a more appropriate witness to answer these questions. So we're going to begin by discussing dues paid by Columbia, Kentucky to the American Gas Association and the Southern Gas Association. Are you familiar with that?
Yes.
Thank you. And can you tell us what portion of AGA dues, if any, was removed from the total of AGA dues paid by Columbia, Kentucky for the purposes of legislative activity, legislative advocacy?
I can tell you what was removed and where that came from. So I'd like to start responding in that manner, and then we can fully vet your question if that's fair.
That sounds fair. Let's
Okay.
start that.
If you can pull up the Attorney General's data request, set 1, number 204.
Just a moment, please. Mr. Leach, did you hear that request? And if so, could you please display that document? And feel free to let us.
Do you mind to restate the document?
Sure, it's response to Attorney General data request set 1, number 204.
Mr. Gore, is this the document that you were referring to?
Yes, it is.
Is there any particular spot you can turn to?
I think the table is the starting point. The AGA dues that were in 2020 are listed, as well as the year-to-date June 2021, the base period, and then the amount that was included in the forecast period of $49,600. Underneath that are the SG&A dues lined similarly. We made an adjustment as detailed in the paragraph below to remove $2,338 from our O&M expense related to a calculation trying to mimic the lobbying expense allocation that would be included in the AGA dues. And as stated, there are no lobbying associated with the SG&A dues. So we removed from the O&M claim in this case, the portion that was related to lobbying.
So would it be your sworn testimony in this case that there are no amounts represented in these totals due to regulatory activity, regulatory advocacy, or public relations?
I do not really know the answer to that. It depends on what is encompassed in the definition of lobbying.
Did Columbia, Kentucky make any attempt to identify any portion of these dues that would be removed due to public relations or regulatory advocacy?
No, I'm not aware of any adjustment or reach out to try to calculate that.
Thank you. Now, we're going to move to a completely different topic, and you may decide to punt some of these questions to another witness. I really am not sure, but you helped to sponsor some of the data requests. Columbia, Kentucky estimated that the Line DE inline inspection project would have a total cost of $17 million, with $10 million of that being spent in the year 2021 and $7 million in 2022. Is that correct?
That is correct.
If recovery of the test year forecasted costs for inline inspection of Line DE is denied by the commission in this proceeding, what effect will that have on Columbia's finances?
It's hard to do math on the stand. The 17 million would be incremental plant. There would be depreciation associated with that. There would be deferred taxes associated with that to determine an amount that would be includable in rate base. You would have the depreciation expense and the property tax expense ongoing, based on that. So that would require a calculation, depending on what returns and depreciation rates are used to quantify that value. And not knowing that value, it's hard to interpret what that means.
Okay, thank
Is that
you.
responsive?
I think it is for the moment.
Okay.
Mr. Leach, if I could have you please display Columbia's response to staff's third request, item 7, attachment B, and I believe it's page 5 of 5. That particular attachment has 5 pages. While we're waiting on Mr. Leach to identify that document and be able to display it, I would just like to say that staff anticipates issuing a post-hearing data request in which we're going to ask you to provide a spreadsheet showing the rate base and revenue requirement effect of removing the Line DE inline inspection project from the test year.
Okay.
I think I'm having a health, I think this came up, just having a bit of an issue with the strike. Are you able to see that now?
Okay, Mr. Leach has displayed the table for us. So, among other things, this shows the effect on rate base in the forecasted test period and the effect on the revenue requirement in the forecasted test period of including line DE for inline inspection as an addition to plant in service based on the in-service curve used by Columbia. Is that correct?
Yes.
Okay. However, it only shows 7 million total going into plant in service for line DE inline inspection project throughout year 2022. Is that correct?
This is quantifying the 2022 spend, correct?
Okay. And it is 7 million that is set to go into plant in service in 2022.
That is correct.
Now, is that because that Columbia included the 10 million projected to be spent on the line DE inline inspection project in 2021 in plant in service as of December 31st, 2021?
That is correct.
If Columbia was projecting that line DE project would be completed in December 2022, why did Columbia include the 10 million spent in 2021 in plant in service as of December 31, 2021?
I had that conversation with the folks involved and asked that very question, and I was told that the project would be broken up into multiple parts, and each one would be done individually, and that all of the spend from 2021 would be in place, in service at the end of the calendar year 2021. So that's how I portrayed the numbers with that information that I did verify before we created our revenue requirement.
Okay. Do you know why Columbia, Kentucky did not seek a CPCN for line DE inline inspection project?
I do not.
Would there be another witness that would be more able to ask that question, answer that question?
I would assume that that would be Witness Roy.
Thank you. Would it be you or Witness Roy that would be the more appropriate witness to answer regulatory questions about federal regulations applying to line DE?
Oh, that's definitely Mr. Roy.
Okay, thank you. Then, Your Honor, I have no further questions for this witness.
Vice Chair, any questions?
No questions.
Commissioner Butler?
No questions.
Mr. Gore, I just have a few. You're an accountant, is that correct?
That is correct.
Non-practicing CPA?
That is correct.
You're generally aware of the federal tax code as large as it can be?
I know it's there, yes, sir.
You've looked at it before. The term lobbying was used in the data request response that you asked staff to bring up earlier. I think it's response to Attorney General 2.0. Do you mind remind me which number
There's
that is?
actually two of them.
Okay.
I pulled my marker out. I think it was 204, wasn't it?
Yeah, can I ask Mr. Leach to go back to that document? I think it's in the other tab that he has. There we go. I think it's on the screen now, Mr. Gore.
Yes.
What number is that, Mr. Leach? You mind to scroll up? Yeah, 204. You were correct, Mr. Gore. And you're the respondent here, correct?
That is correct.
All right. And so if you scroll down, Mr. Leach, the explanation for the adjustment were Columbia Gas, or Columbia, Kentucky made a rate-making adjustment to exclude AGA associated lobbying expenses of $2,338. Do you see that?
Yes.
What was the basis for that specific amount?
If you go to staff's data request 5, number 2, the 3.8% is the actual amount that's stated in the Budget Reconciliation Act of 1993. I'm sorry. Let me read let me get caught up on my response before I answer. Okay. Per the Budget Reconciliation Act of 1993, the AGA is required to provide the lobbying expense percentage, and the percentage that is allocatable is 3.8%.
Okay. Now, is that, so lobbying is the term that's being used?
Lobbying is the term being used.
Are you aware of section 162 of the Internal Revenue Code?
No, I'm not.
Okay. So 162 of the Internal Revenue Code is trade or business expenses, section 162 generally. 162E specifically discusses denial of deduction for certain lobbying and political expenditures, and discusses that in general, this is section E1, and this is an older version, but I don't think this has changed. No deduction shall be allowed under subsection A for any amount paid or incurred in connection with, and the first one is influencing legislation. Is it your understanding that AGA identifies, for tax purposes, the amount of dues related to influencing legislation or lobbying that is not deductible for income tax purposes, and provides that to Columbia and its affiliates on their invoices?
I'm not sure. It sounds very plausible, but I couldn't state that I know that specifically.
Okay, so do you know why they gave you that percentage then?
Again, I do not know specifically why. I'm not aware.
Okay, so
But it sounds logical.
as a post-hearing data request, I'd like to ask to identify the basis for the percentage that was identified by AGA related to lobbying. What's their basis for coming up with that percentage?
Very
Okay.
valid question.
In your conversations on these responses, did the term regulatory advocacy come up?
No,
How about public relations?
no.
Okay. You were asked a question earlier about line DE and the actual, you were trying to do the calculations in your head of the actual impact. Would it be on a scale of magnitude, whatever term you may use, significant, material, not a big deal, whatever it is, if the company invested $17 million without being able to recover it through rates? Would that have a significant material? What kind of magnitude would that have on the company's ability to earn its authorized return on equity?
The company would not be able to earn its authorized if that was pulled out of the basis for which the rates are determined. So 17 million is significant. I think our capital budget for a year is somewhere in the 60, 70 million range. So you're talking 20% of a year's worth of capital spend equivalent. I know it's over 2 years, not being able to go through the regulatory recovery process. And not only is that now, but that kind of lingers because those assets stay on the books for a long time. So depends on your definition of significant, but 20% of 1 year's capital expense quantifies as significant in my mind.
How many years worth of Columbia, Kentucky's capital budget are you aware of? Like just generally, have you been around the capital budget for 1 year, 2 year, 5 years?
No, I started working on Columbia Gas of Kentucky March 1st and was introduced to the rate case immediately, so.
So can I ask then, Mr. Leach, if you don't mind to pull up the company's direct testimony, and specifically the direct testimony, volume 1. and when you get to volume one of the application, sorry, it's volume one of the application. Volume one of the application is 201 pages long. If you don't mind to just go directly to page 151 of 201. It's attachment DAR2, page 101. Okay, so this is Mr. Roy's exhibit from his direct. It's the variances of actual to budgeted capital. Do you see that?
I do see that.
Okay. And so you were saying, you were talking about the 2021 capital budget or the 2020 capital budget when you mentioned the 67?
I remember the 60 or 70, so
Yeah.
I wasn't sure, but yes.
Okay.
Historically, it has been, well, if you go back 5 years, it's been half that.
Yeah.
So that would raise that percentage that you were asking.
Well, and then even going back 10 years, that would be the entire year's budgeted amount, right?
You're right. You are correct.
Okay, all right, I appreciate it. Mr. Gore, do you have any redirect of the witness, Mr. Sanford?
No, Your Honor.
Okay. Is there any reason that Mr. Gore may not be excused?
No, Your Honor.
Okay, thank you very much, Mr. Gore.
Thank you.
Can step down. So, Mr. Sanford, I would like to take a 5-minute break and then try to push through till about 12:30 for the remainder of the morning. Do you have any objection to that?
That'll be just fine.
Anything, Mr. Bain? Mr. Cook, any objection?
No objection, Your Honor.
Okay, all right, we'll take a break until, let's call it 11:30, and then we'll go through at least till 12:30. right, we're back on the record in case number 2021-00183, the base rate case application of Columbia Gas of Kentucky. Mr. Sanford, you may call your next witness.
Thank you, Your Honor. The company would like to call Ms. Changi live, please.
Ms. Lai, please take the stand. Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes.
Okay, please have a seat. State your name and address for the record.
My name is Changi Lai. My business address is 290 West Nationwide Boulevard, Columbus, Ohio 43215.
Mr. Sanford.
Thank you. Good morning, Ms. Lai. How are you today?
Good, and you?
Good. Would you please tell us what your title is and by whom you're employed?
Yes, my title is Financial Planning Manager. I am employed by NiSource Corporate Service Company.
Okay, and did you cause certain testimony and responses to data requests to be filed in the record of this case?
Yes,
Do you have any changes, additions, corrections to the testimony or data request responses?
I do have one.
Could you please point that out for the record?
Yes, it is AG Set 1 number 208 that I co-sponsor with Mr. Gore, which he already pointed out about the labeling error that we had in the chart.
Okay, so with that correction that's been noted previously, if I were to ask you all the same questions, would your answers be the same?
Yes,
And is it your desire and intent to have your testimony and responses to data requests incorporated into the hearing of the record of this hearing?
yes.
Do you have any materials that you've brought with you today?
Yes, I have my direct testimony and the data responses that I either sponsor or co-sponsored.
Thank you. With that, Your Honor, the witness is available for cross-examination.
Mr. Cook, any questions?
The AG has no questions, Chairman.
Mr. Bain?
No questions, Your Honor.
Counsel?
No questions.
Vice Chair, do you have any questions for the witness?
I do have a few. Thanks. Good morning, Ms. Lai.
Good morning.
From a very big picture view, can you explain to me how NCSC allocates O&M costs down to Columbia?
I would like to defer that question to company witness Suzanne Taylor.
Okay. Then all of my questions related to that, so you're off the hook then. I'll wait for Ms. Taylor. Thank you.
Commissioner Butler, any questions?
No, sir, no questions.
I just have one, and I don't think that Ms. Cole could speak to it earlier. I just want to ensure, are you an employee of Columbia Gas of Kentucky?
I am an employee of NiSource Corporate Service Company.
Okay. All right, and that's, there's a number to that. Is that company 12?
Company 12, yes.
Company 12.
Yeah.
All right, thank you very much. Mr. Sanford, do you have any redirect to the witness?
No further redirect, Your Honor.
And is there any reason that Ms. Lai cannot be excused?
No, Your Honor.
Thank you very much for being here today.
Okay, thank you.
All right, Mr. Sanford, do you have an additional witness?
Yes, Your Honor. We'd like to call Ms. Susan Taylor, please.
All right, Ms. Taylor. Ask that you, once you take the stand, please remove your mask and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please have a seat. State your name and address for the record, please.
Suzanne Taylor. My address is 290 West Nationwide Boulevard. That's Columbus, Ohio 43215.
Counsel, you may ask.
Thank you. Good morning, Ms. Taylor. How are you today?
I'm great. How are you doing?
Good. Would you please tell us what your job title is and by whom you're employed?
I'm Director of Financial Planning, employed by NiSource Corporate Services Company.
Okay, thank you. Did you cause certain testimony and responses to data requests to be filed in the record of this proceeding?
I did.
Do you have any changes, additions, corrections, or edits to the testimony or data request responses?
I have one change that I wanted to point out, and it's regard to Attorney General question from Set 1, question 139, and it's related to initiatives. that were included in the budget for the forecasted test period. And there was an error in the calculation not including the voluntary severance program. And so the initiative amount should have been higher in the amount of $2,250,000. And that's not including the additional efficiency adjustment I included of $666,000. So I wanted to point that out because the number is a little lower, and I know the commissioner had a question on that.
Okay, so with that one correction, if I were to ask you the same questions this morning, would your answers be the same?
They would be, yes.
Is it your desire and intent to have your data request responses and testimony incorporated into the record of today's hearing?
Yes,
Did you happen to bring any materials with you to the witness stand today?
I did. I brought a binder that includes my direct testimony and my data request.
Okay, with that, Your Honor, tender the witness for cross-examination.
Mr. Cook, any questions for the witness?
No questions, Chairman.
Mr. Boehm?
No questions, Your Honor.
Ms. Frederick?
Yes, Your Honor.
Ms. Taylor, this is not necessarily a question, but it is a request, and it's the only one that I have of you. The correction that you just referred to the company's response to the Attorney General's Set 1, number 139, could you file that correction into the record? We were not able to record everything that you said. So if you could just file that correction, I would very much appreciate it.
I can do that, yes.
And Mr. Sanford, I doubt that this is something we're going to ask as a post-hearing data request. We just ask that you do it as an errata.
Sure. Be happy to.
No further questions.
Vice Chair Covage?
Yes, good morning, Ms. Taylor. I don't know if you heard my last question where I had asked, just in a broad overview, how does NCSC allocate O&M costs to Columbia?
Yep, I can answer that. So there's two ways that costs go through corporate services, and it's the contract billing is executed through a contract, and then the other type of billing is through convenience billing, and that's basically payments that are made by corporate services on behalf of other affiliates. It's really a convenience payment, and those costs actually reside at Columbia Gas of Kentucky. And so costs are come through different, types of services rendered, and based on those services, allocations are determined. So for example, if it's a cost related to customer, then we have an allocation factor that's related to customer counts, and that allocation would be used then to bill out those costs.
So and I want to make sure I break it down so I understand. I take it there are probably some costs that NCSC knows 100% of this cost I am incurring right now is for Columbia, and that is allocated. But others might be allocated among different subsidiaries on a percentage basis. Is that a fair assumption?
Yeah, so the first thing we try to do is have folks direct bill where reasonably possible. And I think you can see from the data request that's, roughly 32% get direct billed on to Columbia Gas of Kentucky. And so then at other cases where it's not directly reasonable, then we would use an allocation to do that. And again, we've got different allocations, and based on the activity, then allocations are determined based on that. And we do have a cost allocation manual, and I know that question came up before, that we use.
In the settlement, Columbia has agreed with the Attorney General to reduce the O&M cost down. Can you give me any explanation how that number was arrived at? Were you part of those negotiations?
I was not part of the negotiations.
Okay. Then that is the end of my questions. Thank you.
Commissioner Butler, any questions?
No questions.
Ms. Taylor, what economic incentive does NCSC have to lower O&M expenses that it allocates to subsidiaries?
Can you repeat the question?
What economic incentive does NCSC have to reduce the O&M expenses it allocates to its subsidiaries? We would draw that question out this way. You're aware of the general companies that NCSE allocates costs to its subsidiaries? Are they
Yes.
primarily rate-regulated utilities
Yes.
that, similar to Columbia Gas Kentucky, are able to use their reasonable O&M expenses in setting rates? Okay. So the fact that it's able to pass through these costs to subsidiaries that are ultimately permitted to include those in the rates that they're able to charge customers, what economic incentive does NCSE have to reduce or maintain reasonable levels of O&M expenses? What economic incentive is there for them to do so if they're going to pass it on to rate-regulated entities?
Yeah. In terms of economic incentive, I don't know if I can answer that, but our incentive always is to, lower the cost for the customer. And so when you look at corporate services, the costs are, passed at cost, and they're based on market. So whether it's labor or how we're procuring goods, it all goes through a competitive bidding process. And just recently, we went through, analysis of our costs through our enterprise business services to look at corporate services. So they're, with that in mind, it's always how do we better what we're doing for the customer.
Yeah, and so you were talking about the enterprise review. Would you agree that that's significant, by millions of dollars, reduce the O&M expenses that Columbia Gas Kentucky gets allocated or incurs itself?
As far as Columbia Gas of Kentucky, it's not millions. It's a few $100,000.
Okay. Well, how about across the entire NiSource enterprise? How many millions do you know how many millions of dollars in O&M that this NiSource Next program helped reduce?
I mean, I think if you just do the math, I would say, if Columbia Gas of Kentucky is getting a little less than, 4%, then it's roughly,
We'll call it 20 times whatever 20 plus times whatever Columbia Gas is representing their reductions were. Is that fair?
20 times. How are you getting 20 times?
Well, you said Columbia Gas represents about 4% of the allocated costs.
Yeah, a little less than 4%, yeah.
Okay, so out of the total pie, 4%,
Yeah,
25 times that would be the full 100% pie of savings, correct?
correct.
Okay. In terms of allocation of costs, O&M being maintained, let's say at the lowest reasonable amount, based on your experience, what's in place to ensure that they don't get out of the bounds of reasonableness to the point where there requires another, complete enterprise-wide NiSource Next type review? What that you're aware of is in place to ensure that that isn't necessary again? That there are constraints on increasing O&M on a periodic or daily basis?
I mean, just the basic constraints of, one, we have a budget that gets reviewed by, the board, our management, and it's something that we, have to take to stakeholders on the street. So we've got a commitment, right, that we're making. And so there's that we're upholding, and so we're reviewing those costs. You can say daily, but on a monthly basis, we're reviewing those in detail to make sure we understand those costs.
Right, but wasn't that the case before NiSource Next?
But even before NiSource Next, there was, initiatives in place. So we're continually looking at ways we can do things better. And I think Mrs. Cole mentioned that before, but it's not that there's one program right now. It's a continual, how do you look at the way that you're doing things and get better?
Good. So the agreements that are in place to allocate costs to Columbia Gas, it's my understanding, and I can't cite you to the record, but that was last created or amended or agreed upon about 5 or 6 years ago. Is that your understanding?
It looked like 15.
I think it was in 2015. That's right. Are you aware of generally the provisions of those agreements?
I am.
Okay. And do those include methodologies and cost categories, or do they include specific amounts that will be allocated?
They include methodologies. The agreement does not include actual amounts.
Okay.
But those come through those monthly reports that I was referring to.
What do operating companies within the enterprise, like Columbia Gas of Kentucky, what ability do they have to be concerned or push back on the size of the cost categories or the size of the costs allocated to them?
Based on the agreement, they do have the ability to review and question categories or the charges they're getting billed.
Okay, but do they have the ability to dispute or, or to push back or to, effectuate reductions if they believe the amount that they're being allocated is unreasonable?
Yeah, they do have, based on this service agreement, there's a section in there, they do have the ability to dispute. And as I mentioned, there are monthly meetings that take place where discussions on whether it's, contract billings, those can be discussed.
And is it that they're able to dispute whether those costs are being allocated in accordance with the agreement, or are they able to dispute, the size or magnitude of those costs?
It could be either. Yeah, so basically what the scope of the services are and the amount.
Okay. And I would just ask as a post-hearing data request, a citation to that provision that provides the operating companies to be able to dispute the magnitude, not just the methodology of the, or the violation, for instance, of the agreement. My other question on this front is, are you aware of any operating companies that have done that have objected to the magnitude of expenses, not merely argued that the expenses allocated to them were allocated not in accordance with the agreement?
We've had affiliates dispute or, whether it's challenging charges. I'm not sure about the magnitude, but that would normally happen in one of those meetings that I'm talking about. So maybe not formally, but informally, just discussing charges.
But you were talking about the provision that allows to challenge it. Are you aware of anybody that has done that?
To challenge the
Challenge.
the number or the scope?
The magnitude.
The magnitude. I don't know formally if I have
Okay.
seen that, but I have seen challenges come through.
Okay. And then I'll ask you the same question that was asked earlier. Are you an employee of Company 12?
I am.
Okay. Those are all the questions I have, Mr. Sanford. Do you have any redirect?
No redirect, Your Honor.
Is there any reason that Ms. Taylor can't be excused?
No, Your Honor.
Thank you very much for being here today.
Mr. Chairman, if you'll permit us a moment, the next 8 witnesses will be called by Ms. Hoeniger.
I see that. Take your time.
We'll call Suzanne Surface next. I'll let her come up with them.
Ms. Surface, please raise your right hand. Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please have a seat. State your name and address for the record.
My name is Suzanne Surface. My address is 290 West Nationwide Boulevard, Columbus, Ohio.
Ms. Hoeniger, you may ask.
Good morning. It's still morning, right?
Almost
A few more minutes.
afternoon. Good afternoon.
Can you state your title for the record for me, please?
Yes, I'm Senior Vice President of Enterprise Transformation for NiSource.
And are you the same Suzanne Surface that caused some responses to data requests and rebuttal testimony to be filed in this proceeding?
I am.
Do you have any additions or corrections to make to any of those documents?
I do not.
Okay. If I were to ask you those same questions today, would your responses be the same?
They would.
And is it your desire and intent to incorporate those documents into the record of this proceeding?
Yes, it is.
And did you bring any materials with you to the witness stand today?
I have my binder with those data responses and rebuttal testimony that I filed.
The witness is available for cross.
Mr. Cook, any questions?
No questions, Chairman.
Mr. Bain?
No, Your Honor.
Ms. Frederick?
No questions for this witness, Your Honor.
Vice Chair, any witnesses? Or any questions for the witness?
No questions.
Commissioner Butler?
No questions.
I just want one clarifying question. Are you also a Company 12 employee?
I am, sir.
Okay, thank you. Ms. Honecker, do you have any redirect of my
I do not.
singular question?
I do
All
not.
right, thank you very much for being here today. You may be excused. And at your convenience, Ms. Honecker, you may call your next witness.
We call Jennifer Harding.
Ms. Harding, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please have a seat. State your name and address for the record.
My name is Jennifer Harding. My address is 290 West Nationwide Boulevard, Columbus, Ohio, 43215.
Good morning.
Good morning.
Can you state your title for me, please?
My title is Director of Income Tax Operations.
And who do you work for?
I work for NiSource Corporate Services, Company 12.
Okay. And are you the same Jennifer Harding that calls direct testimony, rebuttal testimony, and responses to data requests to be filed in this proceeding?
Yes, I am.
If I were to, do you have any additions or corrections to make to any of those documents?
I do not.
If I were to ask you those same questions today, would your responses be the same?
Yes, they would.
And is it your desire and intent to incorporate those into the record of this proceeding?
It is.
Did you bring any materials with you to the witness stand today?
Yes, I have a binder of my direct testimony, rebuttal testimony, and responses to discovery.
Okay. A witness is available for cross.
Mr. Cook, any questions?
The AG has no questions, Your Honor.
Mr. Bain?
No, Your Honor.
Ms. Frederick?
No questions from staff.
Vice Chair Cubbage?
No questions.
Commissioner Butler?
No questions.
Only questions I have are tax related. Good morning still. Were you able to hear the questions that from Mr. Gore related to income taxes?
Yes, I was.
Okay. Are you aware of the inability to deduct expenses related to business expenses related to influencing federal legislation?
Yes.
Okay. And well, let me ask it this way: are you aware generally of Section 162E of the IRC that says that those business expenses relating to influencing federal legislation are not deductible for income tax purposes?
Yes.
And do you have any idea whether or not that's how the American Gas Association calculated that lobbying amount, was using the language from 162E of the Internal Revenue Code?
I'm not aware of them calculating a percentage for that disallowance. I'm aware of statements that they make on their invoices that indicate that they have not included amounts related to 162E or have limited a percentage of certain membership dues.
Okay, and that's what I want to get to. So you're the person that has to actually ensure you don't deduct that amount of the dues for income tax purposes, right?
That's correct.
And so you've reviewed those individual invoices that the AGA sends?
Yes, we review the invoices to make sure that we've captured those percentages. That's a part of our process when we're calculating the lobbying, the disallowance for expenses for lobbying.
Okay, and is it clear to you that on those invoices they note that the amount related to lobbying is related to their application of the 162E exceptions?
That's the statement that they would be affirming on the invoices. Either the amount captured in the invoice does not include lobbying expenses, referencing that the Internal Revenue Code Section 162, or a percentage of disallowance for membership fees that they've identified. But we've never questioned the methodology for identifying the percentage.
Okay, all right, thank you very much. Do you have any redirect, Mr. Honecker?
I do not.
Okay, all right. Any reason this witness may not be, is there any reason this witness can't be excused?
No, Your Honor.
All right. Thank you very much for being here today.
Thank you.
And take your time, Ms. Honecker, just before you call your next witness, I think, oh, there, they are in here, okay. It's slim pickings in here, so.
I didn't see her when I first turned around either, so.
You may call your next witness.
We call Kimberly Cartella.
Ms. Cartella, please raise your right hand. Do you swear or affirm that the testimony you are about to give is true and correct under penalty of perjury?
Yes.
Please have a seat. State your name and address for the record.
Hi, my name is Kimberly Cartella. My business address is 3101 North Ridge Road, Lorain, Ohio.
Can you state your title and who you work for, please?
Yes, my title is Director Compensation, and I work for NiSource Corporate Service Company.
And are you the same Kimberly Cartella that calls direct testimony, rebuttal testimony, and responses to data requests to be filed in this proceeding?
Yes.
Do you have any additions, corrections to make to any of those documents?
No.
If I were to ask you those same questions today, would your responses be the same?
Yes.
Is it your desire and intent to incorporate those documents into the record of this proceeding?
Yes.
Did you bring any materials with you to the witness stand today?
Yes.
And what are those?
I brought my testimony, discovery requests and responses, and my rebuttal testimony.
The witness is available for cross.
Mr. Cook, any questions?
No questions, Chairman.
Mr. Bame, any questions for Ms. Cartella?
No questions, Your Honor.
Counsel?
I have just a couple questions, thank you. This question involves response to staff's third data request, item 31, involving the Columbia, Kentucky's profit sharing program. And my question is just explain what demonstrable evidence Columbia, Kentucky has that there is a benefit to ratepayers for Columbia, Kentucky seeking recovery in rates for the expense it incurs by paying a profit-sharing benefit to its employee.
Okay. So can I take a moment and find that? You said
Yes.
331?
Yes.
Okay.
Item 31, staff's third data request.
Yep.
You were responding to some questions about the profit-sharing program, I believe, amongst some other things. My question just involves, what benefit is it to the customers of Columbia, Kentucky, that Columbia, Kentucky seek recovery in rates for the expense that it incurs by engaging in this profit-sharing program with its employees?
All of our benefits programs have a goal to offer competitive compensation and benefits to our employees to attract and retain talent. And as part of that package, we have included a profit-sharing program by which our employees receive an amount of money deposited into their retirement savings account as part of our 401k program if certain discretionary funds are made available. So to respond to your question, I would say this is part of our competitive compensation and benefits package that allows us to maintain or to retain and reward or retain our talent.
Has Columbia, Kentucky done any particular study about its compensation packages, salary benefits combinations that directly relates and correlates to a benefit to the customers of any particular element of your package?
No, our primary goal is to design comp and benefit programs that are competitive, cost-effective, and attract and retain talent.
Okay, and you mentioned that discretionary percentage. In a post-hearing data request, I'm going to be requesting that discretionary percentage for the last 5 years,
Okay.
just to let you know that.
Mm-hmm.
All right. Thank you. Your Honor, I have no further questions for this witness.
Vice Chair Cabbage, any questions?
No questions.
Commissioner Butler?
No questions.
Ms. Cartella, let me ask it this way. The company has a profit-sharing mechanism where it shares the profit with customers, is that right? Or, not, sorry, customers, with employees?
Yeah. Could you ask that a different way?
Yeah. Is the profit-sharing mechanism a mechanism whereby the company shares its profit with its employees?
So let me explain the profit sharing program. Not sure that I can say yes or no directly to the question you asked. So the profit sharing program is established to recognize employees if discretionary funds are available, and those funds are put into employees' retirement savings accounts.
Right, but what's the basis for the sharing?
The basis for sharing is, on a regular basis, the benefits committee would look at the overall financial health of the organization and determine if a discretionary amount of dollars are available for this profit-sharing program. And the amounts are anywhere from 0.5% to 1.5% of our employees' eligible earnings.
Okay, so is the name, well, let me take a step back. The response, I think you were indicating earlier, it's response to staff's third request item
31.
31.
Mm-hmm.
And the response to item G1, let me know when you get there.
Response to G1, so hang on. Give me a moment to read it.
I've got a problem here.
All right, we'll take a short break.
No, okay, it's good, we're good, okay.
Okay.
Sorry about that.
The response to G1, it starts off as previously stated.
Okay, go ahead.
Okay. There's what you were saying at the bottom, let's say 3/4 of the way through that, there's a sentence that starts off, the discretionary profit sharing contribution is either 0%, 5%, 1%, or 1.5% of eligible earnings. What are eligible earnings?
Eligible earnings are for our employees, their base salary plus their overtime wages earned during that particular calendar year.
Okay, so what percentage, well, let me just say this, is there a stated percentage of the company's earnings that are taken into account in the profit sharing mechanism?
No.
Predetermined?
No.
I don't mean to be flippant, I want to try to be very direct. If this is a profit sharing mechanism, isn't the funding for the profit sharing mechanism profits?
And you're not being flip, but thank you. It's not a direct correlation. It's a discretionary fund that there is not a direct correlation. So if the organization, if the corporation is financially healthy and we determine that we can fund a profit-sharing contribution to employee retirement accounts, then we do. If we determine that we cannot, then we don't. So in some years, we have paid 0%. In some years, we've paid 1%, and I know I'm going to get a data request on that. So it's not a direct correlation, it is very discretionary.
But the purpose of the program is to share the profits that the company makes. If the rates are created assuming this amount is paid out, then aren't you effectively providing the profit to be shared at the outset?
I'm not sure I understand that question.
Well, the company's not going to be sharing its profits under this program as provided. If this amount is recovered in rates, the company will be sharing the amount that was recovered through rates for this, correct?
No, the company will be sharing the amount that is determined on a discretionary basis at the end of each calendar year.
Okay. So, you have an appreciation for how rates are generally created?
In general, yes.
Okay, so, tell me if what I'm about to say is different than your understanding. The Public Service Commission, Public Utilities Commission looks at the company's costs on two sides, capital costs and O&M costs. O&M costs, just O&M costs, capital costs, come up with a rate base or a capitalization. The depreciation expenses recovered in the O&M side, you get a return on and of, the of is through the depreciation of the capital, and that's your revenue requirement at a very high level, right? That revenue requirement includes some sort of operating revenue that represents a return on equity for the company, right? That is the company's profit. That is the company's return. Would you agree that this is not necessarily reflective of that amount or how well that amount is? What the company's proposal is to actually include in this expenses category a amount that may or may not be discretionary to actually pay out this public, let me get it exactly right, this profit sharing mechanism.
If I'm understanding you correctly, the profit sharing mechanism and the payout amount is not driven by the Columbia of Kentucky results amounts or?
Profit.
Yep.
Okay. It's proposed to be recovered through this expenses side right now, right?
I don't specifically know the answer to that.
Well, let me ask this. Is the company proposing, do you know if the company is proposing to include a test year amount for this employee profit, this profit sharing program?
Yes.
Ms. Honecker, do you have any redirect?
I do not.
Is there any reason this witness can't be excused?
No, Your Honor.
Okay. Thank you very much for being here.
Thank you.
As an aside, Ms. Honecker, my expectation is that we will have a good number of questions for Mr. Roy, and so I think we can expect that he will be the last witness we call before lunch.
Okay.
That may help the remaining witnesses go ahead and grab something to eat if they would like.
We call David Roy.
Mr. Roy, please take the stand, remove your mask, and raise your right hand at your convenience. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
All right, please have a seat and state your name and address for the record.
Sure. My name is David Roy. My work address is 2001 Mercer Road, Lexington.
You may ask.
Good afternoon now. All right, or afternoon now. Can you state your title and by whom you are employed?
Sure. My title is Vice President of Operations. That includes construction as well, and that is for Columbia Gas of Kentucky.
And are you the same David Roy that caused direct testimony, rebuttal testimony, and responses to data requests to be filed in the record?
I am, yes.
Do you have any additions or corrections to make to any of those?
Not that I'm aware of, no.
And if I were to ask you those same questions today, would your responses be the same?
They would.
Is it your desire and intent to incorporate those into the record of this proceeding?
It is.
And did you bring any materials with you to the witness stand today?
Yes, just my testimony and the data request that I responded to.
Okay. The witness is available for cross.
Mr. Cook, any questions for the witness?
The AG has no questions, Your Honor.
Mr. Bame, any questions on behalf of KIUC?
No questions, Your Honor.
Ms. Frederick?
Thank you, Your Honor. Good morning, good afternoon. We are now into the afternoon. My first question has to do with the now $890,000 in O&M increase in the forecasted test year. can you provide any kind of support to justify an $890,000 increase in Columbia, Kentucky's O&M costs?
Is that question in reference to any particular program or proposal or settlements?
The question is in general, what do you believe supports an $890,000 increase in operations and maintenance?
I guess I'd be glad to discuss any type of work that we perform or that we're proposing to perform, but I'm not sure what that's in reference
Okay.
to.
Let's turn our attention to the cross-bore project specifically.
Mhm.
Explain specifically how the cross-bore project impacts your efforts to reduce damages to infrastructure.
Sure thing. So cross bores can be a result from trenchless technologies that have been employed over the last few decades. When we originally began trenchless technologies where you would drill underground to install a pipeline or a facility, we weren't, as an industry, aware of the types of risks that could be found or could occur due to that. And essentially, in cases from gas utilities or any utility for that instance that employ that technology or that approach, you could have blindly and unknowingly penetrated a foreign body when you installed those facilities. And so as an industry, we have identified that as a key risk, oftentimes in our DEMP programs, our distribution integrity management programs, as an item that we are aware of and need to address over time. The specific program that was requested as part of this rate case is an attempt to deal with a certain subset of facilities that were more likely to have occurred on our behalf. Now, when we do find cross bores through our, we ran a pilot program over the last few years, and as we evaluated those findings, we found not only instances where our contractors have had a cross bore into some locations, but also where other utilities, whether they be public, private, or whatever, have also done the same to us. In some cases on very old lines, we found where sewer mains have been built around some of our gas pipeline. And so there's various risks that can come about from any of those situations. In the case for us, if we penetrate a residential customer's sewer line, for instance, right, that sewer line could get backed up, and ultimately, if they call out another company to declog that or take care of it, they could penetrate our main line or service line, depending upon what was done, and then have gas backflow up into the residence, causing a really serious situation. In the case of a situation where the sewer line was built around main in times past, which we are finding a decent amount of those, the situation there is the main line is not an environment that's conducive to that we would typically expect, and you can have additional corrosion or other issues occur on that line to where if a leak occurred inside that cavity, inside that sewer line, then that gas could spread throughout the sewer system, endangering building structures and ultimately people. Okay.
I'm aware of the pilot program, and I have a question. Did Columbia, Kentucky do a cost-benefit analysis before deciding to engage in the project that's represented in its application?
Did we do a cost-benefit analysis before we ran the pilot, or before we proposed?
Before you proposed the project that's being proposed in your application?
Not specifically. As an operator, we're responsible for ensuring the integrity and reliability of our system and addressing the key risks that we identify in our distribution and integrity management programs and our transmission integrity management programs as well. And when we identify and have those rankings established, it's incumbent upon us as prudent operators to address that. And so the pilot was to see, do we have a propensity to have these types of crossbores that can cause incidents or potential risks to our customers. And when we found that, we understood that we do have a risk, and irregardless of what the cost is, we need to address and put in place a plan to address that risk accordingly. There's only a few ways that you can go about assessing and determining if you have crossbores. It can be random, right? Or you can take that head on and try to address it and go out and seek those in a methodical fashion. And that's what we were intending to do based on the volume that we found for the main line that was assessed.
Okay. Just wanted to make you aware that as a post-hearing data request, I'm going to ask you to provide the number of crossbores found in each year of the pilot program from 2017 to 2020, and also the average cost of repairing crossbores. And if there are any extreme outliers to that average, if you could just provide a note about anything extreme you might have found.
Sure.
Okay.
I think that there has been a data request on the amounts, but not the other items, so no problem.
And my next several questions are going to relate to the SMRP rider. Are you familiar with that?
I am familiar with the rider.
The proposed stipulation includes an explanation and an expansion of the scope of the eligible pipe the cost of replacing that can be covered under the SMRP. Specifically, Columbia, Kentucky is seeking to recover the cost of replacement of older plastic pipe, sometimes referred to as first-generation plastic or ADDLE-A pipe, that are susceptible to brittle-like cracking. Is that a correct interpretation?
Yes,
of the
ma'am.
request? Okay. Will you explain in more detail what type of pipe is susceptible to this brittle-like cracking, including the vintage and the location of the pipe?
Sure. So, the earliest inception of plastic pipe, the use of plastic pipe in our industry, a type of plastic was used that was a little bit softer, but over time it became brittle and had a propensity that if you apply pressure to it, that it would have micro fissures and cracks along the length of that pipe. And especially one of the common techniques that we employ when we go out to either extend infrastructure, or if we need to repair something or make a modification to it on plastic mainline, we oftentimes clamp down or crimp that line as a way to squeeze it off and stop the flow. And, so whenever we have to perform work on these early vintage lines, and I'll get to some other details that you ask in a moment, whether that or just through compression from, alongside or underneath roads from compression like that, these lines have a tendency to create small leaks that can grow over time as more frost heave and things like that can occur. So it's due to the type of material that was developed at a point around 1981, and plastic was generally started to be installed around the early 70s, around 1970 or so, give or take. What the industry discovered was this kind of issue. Another generation of plastic that was essentially developed around 81 going into 82. And so the industry generally switched to a type of plastic main that does not have that type of compression issue, doesn't have the types of cracking that can occur under normal environmental conditions that our facilities would see over the course of time. Does that answer all the pieces that you were asking me to?
I think it does. And you have mentioned your distribution integrity management plan and your transmission integrity management plan. And I would like you to explain to us how Columbia, Kentucky uses the data in each of those plans, and how you evaluate it to determine whether this type of pipe should be replaced.
Sure. So we collect throughout any given year, we collect all types of data around our infrastructure. Some of it is pretty stagnant. It doesn't change, right? Like the vintages, the installation methods, the locations, a lot of that doesn't change. Other things do change based on time. And a lot of those can be where you have structures and buildings built up around, or road changes, or it could be that you have a certain type of pipeline or facility that can be prone to leak or something of that nature. And we collect all this data as we have issues in the field, or if we have issues or things that occur from a design perspective that engineering gets in. All that information is captured and fed back to a team that supports the analysis of each state's DEMP program. Then what occurs is we have various meetings throughout the year where parties within the state meet with that central team. We review the data, we evaluate very quantitative elements of the data and the situations that we have, and we elevate or lower the different items that fall into the DEMP and TEMP plans as far as rankings go, based on those changing conditions that we have annually. It is very objective data, and every year we produce a new listing that shows the high, medium, and low risk elements for our system within the state. It's not NiSource's system, it's Columbia Gas of Kentucky system, relevant only to our assets that we have.
Okay. Explain if, and if so, under what circumstances would the replacement of this first generation plastic pipe be selected over the replacement of bare steel?
Sure. So we utilize some support technologies to help us analyze the level of risk for the different assets that we have. In the past, we've used an application called Optimane, and we're in the process of changing that system over to a system called Uptime MRP. And those are tools that we use where data is fed in, both geographic, so GPS type data that understands where things are, so graphically and visually, as well as all the different variables and components that go into those assets. And our engineering teams, our local engineering teams, they review and contrast a risk score that is developed from every proposed project, and they make a determination of whether a certain project of different types of main or material should rise to a level of replacement above and beyond something else. So in other words, if we had, right in the past, Columbia's had only an AMRP or SMRP program that encompassed bare steel or unprotected, coated steel, cast iron, wrought iron, materials like that. The inclusion of the first generation plastic, we would then apply that risk criteria, and we do anyway, but we would apply that risk criteria, and if it ranked above any of those other types, then we would include that in the tracker. Our intent, though, is not to create a wholesale plan to where we have a defined timeline to replace that over a certain horizon. We have that in place for our cast iron, which is the end of next year. We have that in place for bare steel, which is 2037. And what we would do is for the first generation plastic, we would bring that in only when those risk scores were above the proposed project for those other material types.
Can I ask a question?
Absolutely.
So, do you have an opinion as to why the SMRP and previously the AMRP exists?
Can you repeat that one more time, Your
So
Honor?
what's the purpose of the tracker?
The purpose of the tracker is that our industry in general, I think most utilities, I've been around utilities my entire career, most utilities try to get the most out of any asset, and the useful life is spread over many decades, okay? What happens in conjunction with some of those original material types that were part of AMRP and SMRP, so in other words, bare steel, cast iron, wrought iron, when they begin to leak, the rate of corrosion on those lines occurs at an exponential rate. And so over the course of time, the leakage gets significantly worse over a short duration as it begins to actively corrode in either internally or externally on the pipeline. And so the issue for both Columbia Gas of Kentucky and generally for our industry is that situationally, you can have a need to replace a high amount or a high volume or mileage of that fairly quickly. And typical rate proceedings would occur, every 5 years, 10 years, whatever kind of a company, or if a commission asked to bring a company in, those decisions would be made at that point in time. But the amount of capital required to manage those programs is pretty significant. It's a big investment, and it's a significant reduction in risk for our customers. And so my belief is that when this program was established for Columbia Gas of Kentucky, that it was just that the leakage rates were at a point to where we knew that they were going to have a significant uptick, which is that's a mathematical fact, and the need to have quick and prompt recovery of that to support the investment needed is the reason likely why the companies submitted the request and proposal to do so.
So to accelerate the replacement of concerning pipe.
That's right.
Effectively. And what you just said with the replacement of we'll call it first generation plastic piping, little A, you're not proposing to accelerate replacement of those. You just said you're proposing to replace them only when they show up as a high-ranking risk profile in your DEMP or TEMP, right?
They're already listed. It's a category in DEMP and TEMP, right? So it's a risk, it's a threat category. So that item, just first generation plastic pipe, is an item in our DEMP plan. It's not in TEMP because of the material type, but it is in DEMP, and it's a top 10 risk for us. I don't expect it to change unless we would significantly reduce it. But the reason why I don't believe it's necessary to substantially accelerate that, similar to the other, is that the rate of deterioration of that pipe is very different in plastic than it is in steel or iron, those early vintages that aren't protected. So it's a very different level of deterioration.
So it doesn't have the characteristics of the pipe that the AMRP was created to systematically accelerate replacement of.
It could, but not now. I think what we looked at in the current filing is when we requested, and I wasn't here at the time, but my belief is when we requested the SMRP, and added the overall safety component, we were employing an SMS philosophy across our organization. And the belief is that if we found an item that, from an asset perspective, on the capital side, because that's what this is capital investment. If we had an asset type or something that we needed to act on quickly, prudently, that we discovered, that we would have the ability to seek recovery in the SMRP on an annual basis. And we proposed that. The commission is allowed staff is allowed to weigh in on that. Ultimately, you all rule on that decision. This is a request to add that item to it because we have seen elevated issues with this pipe, but it doesn't continue at the same rate that you would have on the, again, the deterioration of the other material types.
So have you reviewed the initial SMRP request? Are you aware of it?
I'm aware of it.
That it was based, at least the initial request was based specifically on a concern for low pressure systems?
It was.
Okay. So going back to AMRP, SMRP, you're not proposing to accelerate or focus on this new first generation pipe. You're just proposing to be able to use that SMRP as a capital recovery rider if insofar as it shows up in your DIMP and you have to replace it.
I think the point of it is we're seeing, and I'll get to your direct question really quick. I think the point is we are seeing those projects progress and occur more frequently, the need to replace that. We don't know, it's not as easy to determine over the course of time what that failure rate will be and the risk in those first generation plastic pipes. It's very environmentally dependent. So I guess what I'm saying is that we included that first generation as a way to evaluate it against these other types and ultimately determine if something's more risky than the bare steel that we are getting annually, that it makes more sense for our customers to replace this other first generation plastic.
Right, but that's different than the cost recovery. You're talking about prioritizing replacements, right? Not the cost recovery that what you said was put into place to accelerate the replacement of these bare steel, non-cathodically protected, wrought iron, cast iron mains.
Right.
So what you're saying is you all are looking at this AMRP and SMRP fundamentally different now, as effectively it's a safety recovery rider, but every year the safety needs are changing, and this is just a really convenient way to recover the cost. I'm trying to understand what this is morphed into since it's turned into the SMRP.
Right. I think the intent is still there. It's to address in an expeditious fashion the most risky assets that we have. Originally, it was focused on very specific asset types, and it still is, right, at its core. I think we have found that, and the industry has found that beyond some of these key things that have been identified as well by PHMSA, that there are other things that we need to spend focus on, and that requires a level of investment. And sometimes that's beyond the investment normally required to undertake just the bare steel and cast iron program piece. And so just like when we had the need to really address some low pressure issues, we found this risk, we submitted a request to the commission to be able to recover that because we're going to be doing something over a period of time. We ultimately got approval to do that and to create something that allows us the opportunity to request it and add it. And that's the point of this, is that we're seeing the first generation plastic pipe continue to elevate in our DEMP model based on risk factors and scoring from what we're seeing. We're believing that we're going to continue to have some issues. We don't think that we need to have a defined time parameter to get that done, but it's going to require some elevated costs that are beyond what we would normally see in that space.
So it started off as the accelerated main replacement program.
Yes.
Right? Now it is being proposed to be an open-ended cost recovery mechanism for prioritized lines that show up in each year's DIM.
I wouldn't at all, agree that it's an open-ended construct. I think that we specifically requested this type of pipe because of what we're saying and because of the risk factors involved. And nonetheless, on anything else that's incremental that we've asked for, we propose that on an annual basis, and it can get excluded if if it's not preferred to be managed through the SMRP. At its core is still fundamentally the bare steel, cast iron, and I think we're out of wrought iron, replacement program. But it does give us the ability to, if we have a need and if it's agreed to by the commission, to add something else to get it addressed quickly due to the risk factor that applies to the customers.
So I say open-ended as being, I define open-ended as not having an ending date. You're not saying that the AMRP or the SMRP now has a proposed end date, right?
I'm saying that of the original items, we have end dates on that.
Okay. But you're proposing an item that doesn't have a specified date.
Not as of now, no.
Okay. I'll ask the rest of my questions later. Go ahead, Ms. Frederick.
Yeah.
Thank you, Mr. Chairman. Now, you've mentioned geology as playing a role here in how brittle and how dangerous this pipe can become over time and how quickly. Can you explain to us what types of geology leads to an increase in cracks and leaks in first-generation plastic pipe? And is this geology in Columbia, Kentucky's territory?
Yes, so I'm not a geologist, but I can describe the situations.
That'll
Okay.
suffice.
All right. So anytime where you have a large amount of frost that can occur, the depths change based on geographies and water content, water tables, and things like that. And I'm not qualified to answer anything along those lines. But anything where you have a level of frost that's getting down to our depth of pipe, and that can cause the ground to freeze, expand, and contract on an annual basis, is definitely a concern and issue. Other is any facilities that are underneath road types or areas that are going to get compressed by vehicular travel or anything like that. So within Kentucky, yes, most definitely, we have very much of that. I wouldn't say it's all the locations by any stretch, but we do have, obviously, a lot of our early generation facilities are underneath roadways and not outside of right-of-ways in our own, private right-of-ways. They're generally in the road right-of-way areas. And from a water table perspective, I don't know all the makeup of the state. I'm learning that, but I would say, yeah, the level of frost and the indicators that we're getting from some of the locations where we've had some leakage, it's due to frost heave and that change.
Okay. And I'd just like to ask you to confirm that in your 2020 PHMSA annual report, I was reviewing that and noticed that Columbia, Kentucky still has 316.2 miles of bare steel. Can you confirm that?
I'll trust your number, subject to check the DOT data. Whatever is that was submitted to the supplemental DOT for 2020 would be accurate as of the end of last year.
Okay, thank you. And Travis, Mr. Leach, if you could bring up response to staff's third data request, item number 2. I believe it is PDF page 18 out of 601. It's just the grade 1 leak history comparison. If you have that in your notebook, but we're gonna let Mr. Leach.
You're gonna show it?
We're gonna show it.
Okay.
There's a table. There we go. There it is. Okay. I know it's small, but he's enlarged it for us. Would you agree just by, there we are, by looking at this leak history comparison between bare steel and first generation plastic, that bare steel leaks are significantly higher than leaks in first generation plastic pipe?
Yes, that is true.
In your rebuttal testimony on page 3, you state that this vintage pipe is known to develop stress cracking and fail in various circumstances. Is this a general statement for the industry as a whole, or does it specifically apply to Columbia, Kentucky?
It's a general statement, but it is occurring in Columbia Gas of Kentucky.
I'd like you to give us a few examples of that. I mean, you've talked about how there have been some examples of times when leaks in first-generation plastic were deemed to be more severe safety concerns than something going on with bare steel. So can you just give us a few examples?
Any example that I would likely give would probably be generic from past. If you would prefer to have a post-hearing data request, I could get you specifics on locations and projects.
If you don't mind, in your testimony, give us some specifics, and then I will do a post-hearing data request for anything further.
Okay. So I know that we've had several submittals from our field employees. When I say several, at least 1 or 2 submittals from our field employees over the last year that have specifically targeted, first generation plastic pipe, where they have been performing maintenance activities and other issues where they feel like there's a risk of situational leakage due to them performing maintenance on it. And so those have been identified, qualified, and are in front of engineering to take a look at for replacement right now. We have also had other projects to where we have the actual leakage, just like you would see here, and that we've determined that we're building projects around those to address that leakage in those segments of pipe that are problematic. So that's generic, but I can get you specifics.
How many projects are you aware of where you're building specifically around to address a leak with a first-generation plastic pipe?
I wouldn't know that information. Engineering oversees the development of any projects. My teams construct it, and I weigh in on the DEMP plan and risk, but I'm not sure of the different projects that they've got planned or identified.
Okay, we're going to move away from plastic pipe. And
Ms. Frederick, if
Yes.
we're going to move on to another category, I think it's probably best we go ahead and just break for lunch and then come back and finish with Mr. Roy. Do you have any objections to that, Ms. Hunker?
No.
Okay. All right, we'll take a 1-hour recess for lunch, and we'll come back at 1:45.
My excuse?
we're back on the record in case number 2021-00183. Mr. Roy, you remain under oath. And Ms. Schroeder, would you like to continue your cross-examination?
Thank you. Mr. Roy, there's a lot in the record about in-line inspection for line DE, so I'm not asking you to recite everything in the record, but I am going to ask you some questions and ask you to elaborate on some things that might be touched upon in the record, but that we as staff still do have questions about.
Okay.
Can you explain why Columbia chose inline inspection as the inspection method for line DE?
Yeah, the answer to that is it was pretty clear to us. When you take a look at that line starts off at Lake Carnico and ends at Jim Beam in Frankfurt. And over the 20 plus years of my career, I've rarely encountered, and I've overseen the development and design of projects in 37 states. I've rarely seen a line that means as much to its community and its customers as that one. For Columbia Gas of Kentucky, it is, 1A or 1B, however you want to define it, to another distribution line that goes around Lexington, but they're both tied together. When you look at that line, and this is going to be a little bit lengthy answer because of it, when you look at that line and who all it serves, it directly serves Toyota, it serves Cynthiana, it serves a good chunk of Georgetown, the northern part of Lexington, it serves Frankfurt, it serves Jim Beam, Buffalo Trace, and a lot of other big customers in between and folks. So when you look at who it all serves, but then you take a look at the changing dynamics of federal code and requirements, and you look at historically, operators like Columbia were required to assess high consequence areas, or HCAs, along their transmission lines. And high consequence areas are kind of defined as, the amount of dwellings within a potential impact radius off of that line. So at any point on the line, you take a look and you draw a radius, and you take a look at how many businesses where people, or locations where people tend to congregate, are within that. And for an HCA, it's 20, right? And you use, to define that radius, you kind of look at the characteristics of that pipe, whether it be pressure, diameter, flow rates, a lot of things, right? Environment that it's in. But used to, it was just HCAs that we had to concern ourselves with. Now, with the additional requirements from the mega rule that was put in place in 2020 and what's been added to code, they've added moderate consequence areas, or MCAs. And they're very similar, with the exception of those dwellings are down to 5, right? So it's 20 for high consequence, kind of 5 for the other. A lot of the requirements are similar. Similar place in code where you'll find it. And that expanded significantly the zones that we need to assess on line DE. It went from, currently we have 5 HCAs that are a couple miles in total length, to 17 locations spanning around 5 or so miles of that overall line. Now, you may say, well, that's just 10% of the line, but 17 locations, and as you have growth in an area on any line, or around any line, you have continual change that occurs on the ever expansion of those consequence areas, whether it's HCA or MCA. When we took a look at that, the level of importance to our customer base, the fact that in order to assess those lines in alternative means, and there's a list of which that's in code requirements, I can get into them if you want, but there's a list of options that you can use rather than our ILI, right? Not all transmission lines need to have inline inspection used for the tool. That's my opinion. Others might disagree. It's the best, but not all need it. This line, with the level of importance and the level of difficulty that we would have to pressure test it, which would be, you essentially have to take the two ends of each zone out of service, and you then hydraulically test it. You inject water in, bring it up to 1.5 times the pressure of the line, and then you got to get all the water out, and you got to do everything else. And in the meantime, you got to be able to either support the customers that you have, or you have to take a customer outage. The challenge with the additional moderate consequence areas is that for certain key customers, it would be darn near impossible to support them based on their volumes, location, and what you would have to do. You'd essentially have to build parallel pipelines around it in order to keep them served. A couple examples of that, Toyota would be one specific. Toyota, we would have to build a bypass around it. There's really no way to backfeed it for the volumes that are coming on, especially with the additional volumes that are coming. When you look as you go from kind of east to west, go from Lake Carnico to Frankfurt, you would have challenges on Georgetown. Georgetown is fed by a line called DKT. It's that 1A or 1B. You can kind of square them either way. Line DE feeds DKT. And to backfeed that area would be so limiting on the days that you could do it. It'd be very challenging. All right? Not only that, so even if you get past that, you've got some other limitations and restrictions that you got to be thoughtful of as an operator. We would have to go in at every station point and reconfigure that station, just like we are kind of to set it up for ILI, to be able to accept reverse pressures through it. Volumes going a different way, like you're flowing differently than what you are, and you've got to change all that, okay? So, you're going to have a lot of those same costs on this line to be able to backfeed different ways to deal with 17 different locations. When you then contrast that with the area that is serving, we are seeing multiple large customers having significant growth on it. The town of Georgetown, or the city of Georgetown, whatever it's technically labeled, is one of the fastest growing areas in the state or region, at least for us, maybe even beyond. And over the course of time, as you have to continue to reassess, it's not like you're doing this once. For HCAs, it's every 7 years. For MCAs, it's every 10, with the exception of the first. Since the rule just got implemented, we have 14 years to technically assess that the first time, right? And then from there on after, it's 10. So you've got all these different time parameters where you've got to do these assessments. And with the new requirements, each time you have those time parameters, you've essentially got to do the pressure testing and do all that work, potentially take outages, and those consequence areas grow. So in areas of growth, they expand. They lengthen along the linear length of that pipeline. And on this line, for us, the most cost-effective in our minds, because of all those issues and all the parameters, the fact that we would have to take some outages on major customers, the fact that we would have a difficult time serving our municipalities that are around, and then to boot, when you look at if we would have an incident on that line anywhere, we can't fully backfeed that from any direction other than the core point that it's starting from in Lake Carnico off of, I think it's line E. I might be wrong it's a Trans-Canada line, all right, or TC Energy. So if we would have an incident there, anywhere on it, we would have significant challenges along that whole route, or at least up to that incident point. Our view was, when we think about all those things, and I know the commission staff, if not AG, I had so many data requests on it, quite honestly, I can't remember who. But there were questions around, did you develop, cost-benefit analysis? In my mind, of everything that I've seen over my career, there was no reason not to make this piggable and make it to where inline inspection is the primary tool to be used time and time again, and set it up to where, once it's done, once you have this capital outlay done, you won't have to have it again unless the pipe itself is completely modified, which should not happen. So you would essentially be having a low cost, because ILI is cheap, very cheap compared to pressure testing, once you don't have to make modifications to the pipeline. So from an ongoing perspective where you've got those different intervals and everything else, it was a no-brainer in my mind to do what we're going to do because of the level of importance that line is, who it serves, and the fact that it's going to continue to change over time with the growth in multiple locations.
Okay, I want to focus on the federal regulation aspect of your answer real quick.
Okay?
This mega rule that you refer to, is that a change to 49 CFR 192.917, or does that exist somewhere else in federal regs?
So 17, if you look, and I don't have the code in front of me, but 17 added some requirements to where in the past, an operator like us that only had to do HCAs before, not MCAs, so that you take out 12 zones that we've got to assess now, and just had the 5, it only required you to assess in ways that were predictable, that you would have, and I'm paraphrasing because I don't remember the exact language under the old code, so we could easily grab that. But it required you to essentially, on using any of those assessment techniques, I think identified in like 937 or a couple other spots, actually, it only required you to have certain level of effort applied to assess the line and make sure that it addressed the elements in code. With the change in 2020, it added a requirement, and I don't remember the exact language in 17, but it added a level of effort that any perceivable threat or likely threat along that line you needed to assess and investigate. And so you can do that through other methods, I'll readily admit, right? And depending on the line, those different approaches to assess could be cheap or costly. In our case, this would be cheap, this would be expensive no matter what, all right? So it does give you the flexibility to do that as an operator, with ILI always being the best, but you can do some other options. So for us, that's kind of the change that really impacted, is the addition of the MCAs, the addition of full breadth of taking a look at the line and the potential risk associated with that line. And ILI gives you the best approach. So let me give you something that might be analogous to it. So let's say you have, you're not feeling well, you got a soreness in your arm. You might, to go check that out using something that's similar to assessment techniques, direct assessment's like an x-ray, right? You're gonna dig down on it, you're going to expose it, you're gonna take a look, and the x-ray is gonna tell you what you got right there. Blood work might give you an indication that something is going on, inside. Take a step back. So go backwards from that. The other component of pressure tests is like, it'd be similar to a stress test where you're, making your heart rate kick up. And you might get an indication that at that point in time you may have an issue or you may not. What all those assessment techniques don't do is what inline assessment does. It gives you ability to determine, is there a threat that's present that's not in a situation where it's going to have where a complete failure could occur on that line, but that it could occur over time that you need to address now before it's too late, before it actually happens. Pressure test is going to give you a point in time. It's going to tell you whether that line is good now and only now. DA is going to tell you, it's going to give you a sample location on 52 miles. You might have, 15 to 20 digs. So at that spot, it's okay. But you don't know anywhere else in between. ILI is going to get you the incomplete linear path from the start to the end, and it's going to give you diagnostic information all the way through. And it's going to allow you to address things that could be a potential risk that you're completely unaware of or won't pick up on the other techniques. And I'm not just trying to pitch ILI, but ILI for this project. The point is, it makes sense here. Absolutely makes sense here because of the importance of that line.
I understand that, and my question centers around the federal regulations
Yep.
that you indicate, as you have testified, you're not alleging that inline inspection is required by the federal regulation, and I understand that that is not what you are alleging.
Right.
However, you have testified in your testimony in this case that inline inspection, or let me rephrase, that the methods used prior to now to inspect this line are no longer practicable, reasonable, due to changes in the federal regulations. So I'm specifically asking, what changes to what regulations are you referring?
I'm I'm specifically targeting the additions of the MCAs, which expand the areas that you must assess. And I'm targeting the language in 937, and I could pull it up and highlight it, or I could do it on a post-hearing data request.
What I believe I'm gonna do is send you a post-hearing data request for all of the provisions in the federal regulations that you would use to support the contention that the method used to inspect this line in the past is no longer practicable or reasonable or would meet the federal requirement.
Well, I will say the practical part comes into all the other issues. Nothing in code's going to say you can't use the other methods. Code's going to say you can use any of those, but you need to take the information as an operator that you have and apply it against code. And that's what we're doing. Code's giving you a list of options to deal with the threats that they know that can exist. And we have to take that and evaluate against the circumstance of that line. And so that's why I gave you those additional details, is because for this line, it is impractical to use those other assessment methods.
But your testimony in this application alleges that there has been a change to the federal regulations that means that Columbia, Kentucky needs to take a different approach to inspecting this line than it has heretofore taken. So my question just simply surrounds what changes to which provisions of the code are you referring when you make those statements that federal regulations would no longer accept, if you will,
Yeah.
the inspection method that's been employed in the past.
Okay. I think I stand by what I was saying, but I'd be glad to take the request to make sure that I'm hearing you right and take a look at it and give you that.
Okay, thank you. And also, you mentioned with the addition of the MCAs, Columbia, Kentucky has, 14 years from 2020 to do the inspection?
To do the initial, yes.
To do the initial?
Mhm.
Okay. So that would be from 2020. So you would have until 2030?
Yeah, I'd have to figure out the months and stuff, but yeah, directionally 2034 or something like that.
Okay. Are there any other lines that Columbia, Kentucky plans to implement inline inspection for?
So Columbia of Kentucky only has one other classified transmission lines, T4 line overall in the eastern part of our system. Out of the whole state of our operating territory, the only ones that would, you could potentially set up on the transmission class side are these two. Out of the total transmission miles that we have roughly 52 of them are the line DE, so we're getting most of it with this one. T4 is, roughly 4 miles, give or take. And, that one's uniquely different. There's been no determination on it. Different location, geography, customer, there's 2 HCA's on it. So I'd need to take a look at that one. I don't have as good a feel on it, and we would probably need to put together a true analysis, because there may or may not be the value there to inline inspect that one. I'd rather use other methodologies, but this one, it does.
Okay. Have there been any failures on line DE?
There have not been any failures that I'm aware of on line DE. We have found, as we've uncovered, some of the locations that we are doing work on right now, we have uncovered at those locations some dents or coating mill strip. So any time you have an anomaly on a pipe, it typically will reduce the life of its usefulness. Dents can cause you to have some points of inflection for corrosion purposes, where you could get some holidays on it. Coating strips means that you're not protected in certain spots. ILI will find that. We've found some things like that. But we've not had any incidents. The key thing is we can't afford to have an incident on this line. It's just too important.
Has there been any downtime to portions of the line when it was assessed in the past?
To my knowledge, no. We've used a combination of direct assessment. I think we've used some guided wave on a couple crossings. And I know we've used indirect survey, which is a method to, this can get very technical and I'll stay away from it, but it's essentially a way to use current and voltage as a way to pinpoint where you might have some locations that you want to use direct assessment on. So we've used those methods, and we have not taken any customer outages, to my recollection or knowledge, in the past.
So why would continuing to use the method of inspection that you have used in the past now be responsible for needing to take lines out of service in the downtime that you testified to earlier?
Sure, because we can no longer use just that method to assess the pipe per new code changes. You have to use a combination of DA and a couple others, and really you have to use a level of pressure test, whether that's spike testing, hydraulically spike testing, or using pressure test. The pressure test component is where you have customer outages. You have to take the pipe literally out of service, cap it, inject water in it, bring it up to the pressure, and then you got to pig it, clean it out to get it dry again, and then put it back in service.
And these are the code changes that you will respond to our data request with, correct?
I will. I'll point to the language in code that drives you to have to do the incremental requirements, the assessment requirements, beyond what was historically allowed.
Thank you. For the record, is line DE sectioned off in some way?
When you say section, can you elaborate on what you mean, just to make sure I'm clear?
Meaning that if there's a problem on one particular area of the line, do you need to take the entire line out of service in order to repair that, or if can just a portion
Gotcha.
of that line be taken out of service?
Yep. So line DE, like a lot of our lines, could be used to backfeed, like from a different source. So currently, the way the line is set up is gas is delivered at a station near Lake Carnico. I think it's just the east side of the lake. And then it moves gas from east to west and ends at, there's a station right outside the Jim Beam plant. So if you ever gone Georgetown Road, kind of back to that area, there's a station there. And so what we can do at that point and a couple points along the way is modify the system to flow gas back the other direction. You do have to change some of the equipment out, which is what I was alluding to earlier. And you can't get the pressure, so you can't carry the same volumes of gas and deliver the same way. So those other systems, this line's so integral, it's used to feeding all of them. Our system's set up to where it can support a little bit of volume back into it by feeding backwards, to your point about sectionalizing, but it can't carry everything.
All right. Mr. Leach, if you would please bring up Columbia, Kentucky's response to staff's third request for information. And I'm looking at item 4, attachment C. Mr. Leach, if there's any way possible that you could make that larger, maybe we can scroll through it as we need different sections. And Mr. Roy, please feel free to ask Mr. Leach to scroll up. I know you're familiar with this, so whatever section you feel would be most applicable to answer any of my questions on this, feel free to have him move it.
Are all your questions going to be on this data request?
They're going to be about this particular page of this data request, yes.
Okay.
All right. What criteria was used, was evaluated when you made the determination of whether a particular assessment method was categorized as good, marginal, or poor?
So I'm going to repeat your question a little bit to make sure I understand. Is that okay?
Sure.
All right. So you're referring to the key at the bottom,
Yes.
right?
Yes.
And you're referencing the middle section on benefits.
Yes, and Mr. Leach, if you could scroll down to that section, that would be very helpful. There we go. And my question is, what criteria did you evaluate in making the determination of whether any particular method was good, marginal, or poor?
So you don't have to look at them all to kind of make that determination. What you have to look at, and this is my opinion, but this is based on a lot of history and knowledge just for my whole career. In my opinion, you look at, okay, the industry best practice is ILI, all right? Then you compare to the options that you have under federal code. You have an option of combining DA and PT, which is pressure testing. DA is direct assessment. You have an option of combining those two together and using both of those methods to fulfill the obligations, or ILI alone. You don't have to do the other two, okay? And so when you take a look at it, there's, and just speaking specifically to benefits, this isn't the customer issues, this isn't, you know, all of those problems that you would have. And it's not including the cost to retrofit. When you look at PT on the subcritical flaws, what it's saying there is, remember when I mentioned on pressure test, it's a point in time understanding of whether that pipe could fail if you had certain situations. It'll give you a point in time information. It gives you no information along the path of that line if you have something that is problematic but not yet risen to where that line's going to fail yet. Okay? And so then you apply that issue, which is, you know, in my mind, a big flaw. You apply that issue to the line itself and the importance of that line and what would happen if you miss something and that line goes down. That's how we got to that, and that's kind of the application that I use. It's, you know, whether it's the quick test or whatever, like I said, the T4, there's more analysis that would need to be done because it's not going to hit the level of importance. It's important to certain customers, but is it worth the cost? That's something that we'd have to analyze. This one, in my humble opinion, I can't afford to have that line go down as the person overseeing operations for the state. That line goes down. Number one, with the pressures that are on it, it's not going to have a leak. It's going to essentially have whether you would have it would be a major incident, let's put it that way, with the pressure that's on that line. You're not just going to have a small leak occur. That's why for those types of lines that are labeled transmission class, they have that impact radius, because you're not going to kind of have a leak survey and you're going to detect a small leak on it. You're going to have a major incident, that line's going to go down, there's going to have to be an investigation, and I don't know when I could get it back up. That's dependent upon regulatory bodies, some of which are state, some of which are federal.
Do these assessment results apply to line DE particularly?
No, this is in general. These are the benefits, you know, and the situations that are inherent to those methodologies.
Do these results apply to Columbia, Kentucky?
They apply to any transmission line that you would want to use these with.
Okay. As a post-hearing data request, I'm going to ask you to provide the supporting documentation for the cost per mile estimates that appear on this document.
Okay. And I could be mistaken, because like I said, I've had a ton of data requests on this. I'm thinking that that's in, that's been submitted, but I'll make sure that if not, we'll get it to you.
Oh, thank you.
Yep.
And Mr. Leach, I think we're finished with that. And you have mentioned this in the past, but could you just provide some support for your testimony that where you stated that modifying line DE to be able to accept inline inspection would lead to lesser costs in assessing the line in future years?
Did you say there was a place in testimony that you were referencing?
Not particularly, but you testified to that earlier in your testimony today.
Okay, so if I'm remembering correctly, what I was saying there is initially there's upfront cost to modify the system, right? To accept inline inspection capability. You have to be able to pass the tooling through the system as live gas is going. And just to give a little background on that, the things that we have to do to modify are at different points when this line was originally built. Inline inspection wasn't, they were starting to use some pigging technology, but mainly they had a line attached to it and they'd take it down so far and have to pull it back. Nothing like what they have now, nothing with the technologies they have now. And so when they built it, they put bins in it as such that at times to get around maybe right-of-way agreements or something else, or maybe a creek, that the angles of that line aren't capable of a pig or a tooling mechanism passing through. So we have to cut those out and have wider sweeps to be able to allow that to happen. And also one of the biggest areas is every station along the way, in order to be able to minimize the cost of it and have one launcher at one end and a receiver at the other. So basically where you put the tooling in and where you get it out, at one point at the end of the 52 miles, you've got to modify the piping that is part of each of the measurement and regulation stations along the way, okay? So those are the things that are done. Once you have that up front, going forward, all you have to do, everything else is in place. All you have to do is when you hit your inspection cycle, which would, for us, what we would do is every 7 years, we would go ahead and inspect and just eliminate the funkiness of the overlapping 10 to minimize extra trips to inspect. But you would just have that tooling ran, you'd get your data, and you'd be done. And that's just a few $100,000 normally for setups of the contractor, bring the tooling out, and the diagnostics on it. I don't know that, I've got cost data in here, I'd have to go back and look at it, what exactly it is, but there is pretty much no capital outlay. It's all O&M from that point on.
Okay. I only have 2 more questions for you.
Sure.
Do you know what the payback period is for the investment to retrofit this line?
No, because with the changes in code and the additions of the MCAs, we've never had to compare the alternative of what we've been doing against it. Does that make sense? So we now have we have 17 instead of 5 locations that we've got to assess. And those additional 12 are the MCAs, and those are wider and longer because they're less restrictive, but it's part of code. And so I don't have any history on doing that work. So when you're trying to look at compared to what we've been doing and what's the payback in comparison, I don't have a starting point. I'd have to actually do that once,
Okay.
or estimate it.
Do you know why Columbia, Kentucky did not apply for a CPCN for this project?
So back when we were talking about this project, we did request it in the SMRP filing last fall to be added to that mechanism, regulatory mechanism. When we were discussing it, I remember having discussions with regulatory and legal, and from what feedback I got back was that this is part of the ordinary course of business, that we are required by code to assess these lines. We have to do it in some way. When we looked at cost, yes, it's expensive, being 17 million, but felt like it was within bands of some other data that we've gotten in the past. And I'm guessing Judy Cooper would probably have a better detailed understanding of that, because I know she was part of the conversation.
All right, thank you very much. Mr. Chairman, that's all the questions I have for this witness.
Vice Chair, any questions?
Yeah, just a couple. I think most of them have been answered, but I just wanted to just briefly about the line DE upgrade expenses. Just in your experience, would a single capital project that is 10 to 15% of the capital budget for a year be considered a significant project?
I guess when you look at just one capital year, yes. When you look at all the rate base, it's not nearly anywhere near that. So it just depends on what parameters you're going to look at.
Okay. Was there substantial analysis undertaken, engineering, financial, before launching into this project?
Launching the what? I missed the last part.
Launching into the line DE upgrades.
Yeah, absolutely. We did a significant amount of assessment on the line to determine what all would be needed. A line of that length, we knew we had some locations from our historical drawings and maps from when it was installed. I think it was installed at 3 different junctures over time. Maybe initially when Toyota came along, we've historically called that the Toyota line because that's how that line got built. So that's how employees think of it. But because of those 3 segments, we knew that we had several locations that we had to assess and determine whether a pig could pass it. So we dug down, exposed a lot of those areas. That was work that we did in advance to determine how many locations we would likely need to work on and fix to be able to pass that pig. or those
Okay.
bids.
And I'm correct that you called this a capital expenditure, am I right?
It is for the upfront investment, yes. Future assessments will be operation and maintenance expense.
Okay. That's all the questions I've got. Thank you, sir.
Sure, thank you.
Commissioner Butler, any questions?
No, mine have been asked. Thank you.
Mr. Roy, I just have a few. I'll start with this line DE. How old is line DE?
Subject to check, I think the first segment was put in around 86, I think.
And it runs and ends here, just above Forks of the Elkhorn. Is that where the Jim Beam factory is in Franklin? Is that
Yeah, where you see that big sign where you go by, there's a station right there.
fenced in?
Yep.
What happens if you run a ILI on this first run, you find a significant place of significant concern, and you have to take this line out of service anyways? It sounds, forgetting doing ILI, just the redundancy is sort of, lack of redundancy here is just sort of concerning for me, that even if there is, forget finding the problems, right, through a direct assessment, what if it has to be taken out for service?
So it's a great question, and in fact, we're doing that as we're doing the work at different times. Unlike a pressure test where it's going to take a relatively lengthy outage to be able to start and end it, what we're doing as we're going through and cutting out fittings, we do have to take and modify our operational capability of that. But it's brief. We're doing, when we cut out segments, we're taking maybe a pressure reduction in an area that we've already looked at from a planning perspective and that we can make happen. And it's normally, less than a day, portion of a day or something like that. So if we would have an anomaly that's found, and we'll likely find some, I mean, that's the reality when you do those things, we would do the same thing. We would plan that out based on the severity of it. We would work with any customers. If we did have something close to some key customers, we would work with them on doing it based on the risk level of the find and the concern and location. So the key is, on any line like this, it doesn't make sense to have complete redundancy. The cost would be astronomical for the community and the customers. What it does make sense to be able to do, though, is if you do have to do something, to plan it. Having something instantaneous where there's no planning is a mess. We can't, like I mentioned earlier, we can't completely backfeed everything, but we can make preparations to minimize impact if we have time and can work with folks. And so that's what we do on this. If necessary, we'll contact the customers that are localized to that part, or that I believe staff attorney made mention of circumstances of sectionalizing. We don't necessarily completely call it that, but to the point, we can do certain things as long as we can think through it and plan through it. We just can't do it over a horizon. Like when you pressure test, it's not like it's a small little segment that's 15, 20 feet. We can do a bypass on that for relatively low cost. We can do other things. But what we can't do is when you're 1,200 feet, 1,500 feet, stuff like that, to build a bypass would be millions of dollars in and of itself. So we can't keep customers in service that way, but you can, if you find a specific incident or an issue on the line, you can plan around that with folks.
What outages would occur if every 7 years you did a pressure test on line DE? What's the overall number of days, even if you did I know you don't refer to it this way, the sectionalizing and pressure testing different sections, how many days would the entire line be out?
Well, so let's say a customer had to be taken out of service when you do a pressure test, because there's a lot of variables here, but let's keep it simple and say we wouldn't be able to backfeed completely and there would be an outage. On a pressure test, no matter the length, you're probably going to be out a good portion of a week, okay? Versus, and that's because of the length and all the things you got to do to get moisture out and everything else so it doesn't damage customer or other equipment downstream. In in a situation when you're looking out in the future and you're talking about in the future, that's where it's difficult. And that's part of the decision-making process when we took a look at this. And, you know, the path was chosen to go ahead and put ILI in. HCA's are one thing. The increased number and count and distance of the MCA's is another, but those will expand over time, especially around, I would say, from a little bit east of Toyota through, I'd say a little bit west of the Georgetown region. It'd be west of the station that ties into our transmission or our distribution, high pressure distribution line there. That area is going to continue to grow, and over time, there's a very good chance that that will have much larger and more of either HCA's or MCA's as things get built up. So it's really hard for me to predict what type of cost it could be in the future on that, because I don't know what's going to happen to those zones, and I don't know what's going to happen to the growth. It's not slowing down, I know that.
So, but I'm curious about the outages specifically.
Right.
What are you saying, every 7 years, we're talking about 1 or 2 customers taking the risk, assuming constant growth, current amount usage, 1 or 2 customers would have to be out for a week using the pressure test methodology moving forward?
Well, when I say 1 or 2 customers, I think of communities and major customers. Like majors are the names that I mentioned earlier, the others are communities. And so the potential there, that, you know, number one, like I said, MCA's and HCA's had different frequencies. With ILI, we were going to do it every 7 just to minimize O&M costs. You could do that with pressure testing, but I don't know that we would assess as frequent with MCA's. And on one hand, that'll be less costly because it's now every 10 years. On the other hand, that's, you know, as of right now, 17 potential times where you could have customer impacts, you know, over that 7 to 10 year time frame. And even then, you're only getting a sample size of that line. You're not getting, like, you're not getting the rest of it. And any point in there, any point along that linear path for this line could cause further disruptions if we would have something and we just wouldn't be aware of it because of the method we chose.
So that's pressure testing, direct assessment. Let me ask this about direct assessment. We have an estimate, on, at least on a NiSource-wide estimate, as to what the cost of direct assessment is per mile at different lengths of height, right? That's what that exhibit that was shown earlier was, correct?
Right.
So is that, is direct assessment exclusively or primarily O&M expense, that integrity assessment methods?
That's correct, primarily O&M.
How about pressure testing? Is that capitalized or is that expensed?
Pressure testing, the first time you got to do it, you're going to have capital outlay like we have on ILI. So you're going to have to make modifications to allow certain things to happen. Once you make that, it's all O&M, just like ILI is.
And have there been capital improvements to the line DE for past pressure testing?
We've never had to pressure test because we didn't have the requirements that code put in place in 2020.
Okay, so for the HCA's that are in line DE, none of those were pressure tested? That wasn't the assessment methodology?
No, it was direct assessment with some indirect survey.
Okay, so so it's all been O&M expense up to now.
Yes.
But now with ILI, it's going to be approximately $17 million in capital, as well as, and I just did this quick math from your data request response. There it was $17,000. It was $14,700 for lines equal to or greater than 15 miles times 52 miles is just about 700 and it's not about. It is $764,400 for a 52 line mile at that amount. Would you agree?
Based on this information, yes, we would bid it out. We would see what we would get. This first time, when we we're under construction on all this, as you guys are aware from the data requests. So the first inline inspection usage will be capitalized. That's allowed, by FERC accounting. After that, it will be expensed. So the first passes and all the first level assessments that we send tooling through, that'll be capital. But from this point forward, once we do that initial every 7 years, it will be expense. So that'll be O&M.
Was any preference given to ILI because the companies are able to earn a return on the capital expended as opposed to the O&M expended for other assessment methodologies?
Absolutely not.
With the ILI, is the intention to run the pig with single runs over the entire 52-mile distance?
Yes, the intention is to have one long-term receiver. And since gas flows from east to west, you'll have your launcher over by Lake Carnico and receiver by Jim Beam at that station. And so the intent is to have one. You're going to send some cleaning pigs to clean the line. Then you're going to send geometry pig to get an understanding of the makeup of the line itself, and then you're going to have some additional diagnostics. But yes, it'll be one run for each of those, unless the cleaning takes more than one.
Is the line DE a single diameter, the entire 52 miles?
No, part of that is some of the cutouts that we're making to make it pass, and that's mainly at the station locations.
So what are the diameters that are used on line DE?
I don't know them all because some of them are unique to the station, so I'd have to pull that in the engineering data that we have to get all that. Okay. But I could easily do it if you want a data request.
Is the anticipation modifying line DE to be a single diameter or just two diameters?
It will be, I believe it will be a single diameter. Unless there are, it seems like there might be a couple spots where there's a little bit larger diameter than what we need to pass, but it's not so large where it's going to get hung up in the transition fitting that goes to it. And what I mean by that is, let's say you have a 30-inch piece of pipe and a 24. You have a fitting that is welded to both ends that kind of looks like a funnel, right? And so depending upon the direction of that funnel, you can have a lip and it can catch that tool. We'll ensure that whatever is in place is capable. So we'll only replace what we need to, which is just small little pieces, but we want to make sure that tool can pass with ease.
Well, and the reason I ask is they make multi-diameter pigs.
They do, and that's why I said it depends on the tooling, and we'll try to make sure that we use whatever can pass. So we'll only change what we have to.
So can we ask as a posting data request the number of feet by diameter of line DE, the 52-mile line DE, the number of feet of pipe, not just the regulator specifically, but the number of feet of pipe for each diameter?
Yes.
Okay. So in your initial cross-examination today, you noted that this was the most cost-effective method for direct assessment. I want to make sure I understand, is that based off a formal benefit cost analysis, or is that sort of looking at quantitative factors or qualitative factors? It's the only one, in your opinion, that makes sense on a cost-effective basis?
So I heard you say direct assessment. Did you mean?
Sorry, I mean integrity. Yes.
I thought I knew what you. I just want
192 sort of integrity assessment. Yes.
So what you're asking, and I just want to clarify, make sure I got you, is, and it was the decision, and I could have butchered this in trying to think about the first part, was the decision to do ILI based on a cost-benefit study or a reaction to the inherent conditions of the line itself?
Yeah, so let me withdraw it. So you used the term most cost-effective earlier in your testimony. And what I want to make sure of is that that's not a your characterization of a quantitative analysis, looking at links and expected increases in O&M for the other direct assessment and pressure testing, and it's not this output that, using a weighted average cost of capital as the discount rate, that over a 30, 40-year term, this is gonna, the payback period is a shorter time period than using the other two methodologies. That it's a result of, effectively, what you're saying are the qualitative considerations.
So I think it's a combination of two things. One, when I said the most cost effective, I was only referencing post modification of the line. So from the next time, after this is modified, after these dollars are spent, from that point on, it is the most cost effective to use ILI.
After the 17 million.
Right.
Okay. All right. That's helpful. I want to talk about the DIMP for a second.
Okay.
The Distribution Integrity Management Plan.
Mm-hmm.
That is, it's not just a Columbia thing, right? That's
every operator has to put one together.
It's required by operators as defined under 192. You got to have a DIMP. If you have transmission, you got to have a Transmission Integrity Management Plan.
That's right.
Is the DIMP the direct feed-in for the company's SMRP filings?
So yes and no. And if you let me clarify a little bit. Prior to SMRP, there was the AMRP. And although I wasn't in Kentucky years ago when that was established, I don't know if DIMP was in place yet by federal regulation. So there's a very good chance, depending on the two dates, that the AMRP, the precursor to SMRP, was developed pre-DIMP. However, currently, we use DIMP to help us focus our energies on what threats we need to address as a company. And when I say company, Columbia Gas of Kentucky. And if we see something that's pertinent, that the threat is growing, then yes, there is the potential that we could seek the commission's approval to include it in an SMRP filing, of which the commission would have the opportunity to accept or deny. Is that what you were getting at, or did I?
Yeah, I guess my question is, and I think maybe you answered it, is the SMRP the amount of capital the company can spend or has available to spend in the next year on projects of that type applied to the highest priority projects that are created as a result of each run, the annual review of the DIMP?
Sure, right. So for me, I oversee operations for the state, and I tend to focus on, in our DIMP plan, there are a variety of threats with associated risk. There are a variety of threats that are graded. And, for this, the last published DIMP plan back at the end of 2020, we had 10 high risk or high consequence threats that we, based on scoring, okay? All of those, some of those get addressed in capital, some of those get addressed in O&M. So for me, I spend my energy utilizing the O&M and capital that we have, and I don't make complete decisions on capital. I definitely have a weight on that. Engineering takes something that I might think, and they'll put some assessment and analysis together at times for things. But so we will use at our disposal the dollars for O&M and capital to address DIMP. It's just not capital. So for instance, damage prevention for us is high on the threat list, and that is where you have 811, you have locates and your stuff, and so we have both education and we have all types of things that way. Cross-bore one that we already talked about is an O&M one to address, but it was an emerging threat that's been rising based on what we found due to that pilot. Okay, other threats are bare steel or cast iron, and those are normally addressed. You either fix the leaks, but the leaks keep coming, or you go ahead and address it capital.
Let me ask it this way. You have, and I noted it earlier, you have an exhibit that's attached to your direct testimony. That is that page 151 of 201. It's the chart of the last 10 years variances for capital,
Okay.
Budgeted and actual for capital expenditures. Do you know what
I roughly remember the page, but if you're going to ask me something detailed, I'll need to see it.
well, I mean, it goes from, I don't know, 11, 12, 13, 14 million dollars a year in capital to in excess, I think, $64 million in 2020 for the capital.
So that's the AG's first, or no, wait, excuse me, that's staff's first data set?
No, I think that's an attachment to your direct testimony.
Direct testimony,
I
okay.
think it's DAR-2 that
It
you're
is
referring to.
DAR-2. I think it may be DAR-2 page.
All right.
I think it's page 101.
Page 101.
I'll find it, but go ahead and ask the question.
Well, so the actual annual cost, well, let's start with the budget. The annual original budget in 2011 was $12.159 million.
Okay.
The capital budget for the forecasted test period, or the year that falls under the forecasted test period, is approaching somewhere between $60 and $70 million. That is an increase, to say the least, right? That's more than four times higher than what your capital budget, Columbia of Kentucky's capital budget, was in 2011. The company has had an AMRP, SMRP for, let's just call it about a decade, right? I'm curious how the company is balancing increasing capital budgets, increasing costs against the prioritization of the greatest needs. Because O&M is increasing. I know there's been a reflection for a reduction in O&M expense, but damage prevention O&M has doubled.
Yes,
Right.
it has.
Damage prevention O&M has doubled. Capital budget has quadrupled in 10 years. And this is all during a time period in which if we talk again this time next year, my expectation based on what the company said is there will be no cast iron in the Columbia Gas of Kentucky system. There is no more wrought iron. I don't think the company started out with any wood. No wood though. But there's just bare steel and plastic this time next year in the system. And yet the expectation is that the bare steel won't be taken out until 2037. And there's no sort of anticipated acceleration of replacement for the first generation plastic. There's no time period in which to have it removed. So looking at all those sort of data points, I'm trying to understand where it is the company is balancing an ever-increasing capital spend and how they're actually prioritizing those, particularly in individual riders like the SMRP.
Okay, so your question is how are we balancing the increase in costs with the needs that we have for our system operations?
Yeah, let me ask it this way. So with all those things in mind, right? How is the company actually prioritizing? Is the company actually prioritizing its needs, or is the company just increasing its capital to make it much easier to cover all the needs instead of those that have to be prioritized?
No, I would say, like I said, I came to Columbia of Kentucky in the fall of 2019. In my opinion, and like I said, I've been in engineering, operations, or construction and projects my entire career. In my opinion, we're absolutely trying to balance the needs of our customers and the risks that are present on our systems with the cost. And let me give you a few examples, okay? So, like you had mentioned, damage prevention, that budget is completely reflective of people calling 811 and asking us to go locate. We have no control on that, and that has gone up. That's like 250% if my math was right, from several years ago. So there's not a lot we can control with that because we do want customers to call in and do those things.
It's a great thing that they're calling in, right?
Right.
Because they weren't before, there were
That's
no
right.
penalties before, this is all reflective.
And that's why the damage rate's gone down.
Of the 2018 changes in the Underground Facility Damage Prevention Act, right?
That's right. When you look at capital, yes, capital has substantially increased, when you take a look at that. The challenge that we are having and all operators are having are the costs the cost inflation that we've seen in three core areas. One, our contractors. We competitively bid. We have, up till this year, we've had 5 contractors that we have negotiated rates on, and they've been competitively bid in the process. We are finalizing a new round for another, it's either 3 or 5 years, I can't remember, with contractors, and again, competitively bid against the marketplace. So we are trying to handle that, but we've seen substantial increase over a decade. The biggest area, quite honestly, that we've seen an increase on, and it is a direct reflection of the program that we established, being the AMRP, is we have municipalities substantially taking advantage of all operators as we're going and making investment into plant and replacing these lines. The requirements that they're putting on us, compared to what's reasonable, are astronomical. But we have no recourse or limited recourse when we're in road right-of-way on what they want us to do when we touch it. For instance, in Lexington, if I dig a small hole, maybe it's just to do a leak, not even necessarily do a replacement project. They want complete mill and overlay 20 feet in each direction, both sides of the road. And there's not a lot that we can do other than to educate them on the impact that has with all of our customers across our footprint when they escalate costs, but they don't care. So when you look at the cost of a capital project, and let's say replacement, because that's the bulk of what work we do. Out of our capital budget this year, so, let's say 2020, because that's what's on here. So you see, the actual was about $65 million. I'm believing that we were around 41 of that was just, replacement of bare steel, cast iron, or the like type projects. Of those types of projects, around 40 to 50% of those costs are restoration costs. It is literally absurd on what's happening with that. And all of us are facing it. My peer over at another utility in our region.
Yeah, we've heard it from Kentucky American.
Okay, I wasn't going to bring their name
Okay.
up, but
There's been a
we
point of
are all
contention
seeing
there.
that. So those are challenges that, although we have an expectation to perform certain activities as an operator, there are costs that are almost uncontrollable to us that are impacting our customers.
So one of the things, as a maybe a posterior, but it's maybe something we include in the order, is a request that for the most recent fully completed SMRP filing, I guess it's the true-up or the update, to break out those costs to ensure that they show what the restoration costs reflect.
Okay.
What portion of them are reflective of restoration. The other question I have on this front is your inflationary, we'll call it inflationary, your increased expenses as it relates to contractors and lack of availability with contractors. Or, there's only a limited number, right? There's not just contractors popping up out of nowhere every day. And if they are, we'll see if they may or may not be insured, right? I mean, at some point, you have to figure out who you're gonna work with. Has the company looked at in lieu of contractors, especially with knowing that the SMRP, that it's, you plan on using that to replace, I assume the company plans on continuing to use that to replace, at-risk pipe, including bare steel, for the next decade plus. Has the company looked at internalizing those expenses, given there's a significant time horizon that's going to be required to replace those for those programs?
So I would say I have not. I can't tell you if there's not been a corporate effort to take a look at insourcing for the different states. I have looked at insourcing different activities that are in O&M as a potential benefit. What I'm saying is I'm not seeing the value there for the things that I have looked at. But for the capital piece, I know that 2 of the current 5 that we have, their rates would be definitely lower than the current cost structure of our employees that would be overseeing that work.
And frankly, I'll speak for myself, the capitalized labor expenses are the most concerning, because it's not just the actual pass-through of the expense, there's a return of and return on once it gets placed in rate base, right?
Yeah, so understand, but, and I don't have a problem with undertaking that down the road. Obviously, it hadn't been done to date, but I do know that I don't think it's gonna reap the benefit that you're thinking.
I don't know that it would, I just was asking if that's something that you all have undertaken.
Yep.
The last question I have, I forgot to write it down. The last question I have is about the increasing capital budget for the company, particularly the increasing amount that's coming through the SMRP. You, I think in rebuttal testimony, addressed Mr. Dittamore's concerns on this front, where he proposed there to be a cap on the SMRP filing. I think it's in the final 2 pages maybe of your rebuttal testimony. You spoke to, if the commission has a concern about how much we're pushing through the SMRP, they can address that and tell us not to.
That's one of the points I made, yes.
Not to in the SMRP. I guess on that front, it's a little unfair to sort of, if there's a holistic prioritization for the SMRP on any given year, to ask you that on a stand. But as a post-hearing data request, I would like an explanation of how the company is prioritizing projects for inclusion, proposed inclusion each year in the SMRP filing. And part of that, as part of that, I'd like to make sure that I understand that it's not just okay, what are our needs this year, right? 80% of this is DEMP. Another 15 is because Lexington's gonna be working on these roads. We might as well get in, while the roads are gonna be open anyways. Paris, Indiana, whoever it's gonna be is gonna already have them open. We're gonna rush in there. So let's go ahead and move them up the counter, whatever it is. I'm gonna sort of ask in addition to just how are they being prioritized for inclusion each year, if there's an idea by the company in any given year, what the 3 and 5 year, not just forecasted total amount is going to be, but if there's a holistic plan that, this year, these are gonna be these projects, and in the next 2 or 3 years, these are the other projects that we'll be looking at inclusion into the SMRP. And so I'll ask that as a post-hearing data request. But anything that you can provide on that now is great, but I'd just like to understand the bigger, how you are looking at that forecast each time you're filing.
So appreciate that. I've got no problem, obviously, getting the data requests and providing that. And that's a focus on SMRP is what your question's relating to, right? The only thing that I would say when you're looking outward in time, a lot of people think that, and I'll use us, but I work for multiple operators. A lot of people think that an operator has got a 3 or 5 year plan on what projects they're targeting for replacement. For certain key projects, maybe that's the case, but for the volume, normally that's not. And the reason is that you want to use the collected data that you get on your annual leak surveys and other issues that come up. Maybe it's due to system operations in the winter where you're starting to see some issues both from leakage and how that impacts taking care of customers on a heating degree day when it's the coldest. And so those, you definitely substantially tweak annually some of those projects that go into there. And beyond a couple years, you really don't look for those. You really don't look that far out because you want that data to help drive that decision making.
Yeah,
So-
I can appreciate trying to identify the areas of most concern.
Mm-hmm.
But going back to maybe the first couple of questions I asked you when I interrupted Ms. Frederick,
Mhm.
is that the initial basis for the AMRP was to identify and proactively replace those facilities that are of greatest overall concern, because not for the harm they show today, right, or that they pose today, but for the harm they can show or have the risk of showing.
Well, and those that are in the SMRP, keep in mind that they're all the same material type generally up to this point. And so what we learn is that they have characteristics over time where that leakage hits a curve where the rate of corrosion is substantial. So it may not be on our radar this year, but maybe in a year and a half, it does. And so although we're aware and we have all of that we're looking at and in our database for making decisions, when I say it's just the near-term risk that we're hitting on, it's because that segment of line is now at the point that if we don't do something, it's going to create massive problems. And that's kind of how corrosion works, is that you will go from having very little problems to very big problems pretty quickly. And that was the nature of why we needed the AMRP to begin with, or most companies do, is because you just need to have a substantial amount of investment to address that stuff because it's at the end of its useful life. And some of those lines are at different stages in that, but they hit it pretty quickly when they get there.
The last item is about customer-owned but company-maintained service lines. Are you aware of that being the case with a few tens of thousands of Columbia service lines?
So I am aware of, at one point in time, the customer service lines were owned by the customer in the state. At a point in the 80s, that changed. And so I think there was an expectation of going forward from that point as something was needed to be done, that when that line was touched, the company was responsible for taking care of that. That's my general understanding.
I think that's fair. And then, for 811 purposes, identification of those service lines and different things under observation. I'm just curious, are you aware of any internal programs where the company is undertaking trying to ensure that they identify those service lines?
So for those specific ones, because for the ones that we put in, yes, we have service card records for all of those. We know where they were, how they were installed. For any customer, those lines that were that pre-date that then came into our lap, obviously when they have leaks or when they have issues, we replace it, take care of it, customer doesn't see any impact. But for late damage prevention purpose, to the point you're raising, no, we are not progressively going out and assessing the exact location where those are. When we use our locating instrumentation, generally, we do a good job of hooking up and connecting to different points and be able to trace it. Every once in a while, we have some issues to where the way that it was installed and what it's adjacent to, it skews the equipment that we're using, and we wouldn't know that until it's hit. And so that's the predicament for those that we don't know how they were installed, we don't know where they were installed, we know kind of where the meter is and we know where our main is, and we do our best to try to assess those. But To actually figure that out and do something proactive, we would have to go out and actually either use some invasive equipment that allows us to locate that, kind of hook up down on the line, and locate that underground, which that's pretty costly to do and expensive, or we could dig down to it.
So, on that, when you all are requested to do a locate for lines in which did not originate ownership with the company, right? That you all took that over in 1980, whatever it was. Do you all use that as an opportunity upon marking that to map and identify at that time where the anticipated location of them are? Is it a wasted trip in that vein, or do you all take back the information as to where the approximate locate was for later use?
I would say when we do the locate on those, we do not go to the level of absolutely knowing where that line is, because to do so would take quite a bit of time to do it and a lot of cost. Like I said, you'd have to dig it up, see the whole line, or you could use a Jameson reel, tie in, and trace it back, which is a lot of work to do. We do not keep the record and feedback into our data set, the locate that we do perform, because it's directionally accurate, assuming that the installer didn't do something odd or awkward. And we have no idea of what they did, so we'll use traditional methods to try to make that determination. But because we don't know it for sure, it's kind of like if you would install a gas line or anything, and you wanted to go out and GPS it. The ideal thing you want to do for records is GPS it when it's open. You can see it, right? You get the exact points. This would be the equivalent of everything's covered up. You have records that you put a pipe in there, and you're just guessing at the route based on that. So that's why it's kind of the same thing. The data is not perfect, and so we don't want to use it for a factual record. It'd be better just to continue to have someone go out in the rare case that it needs located again and do the same thing.
Ms. Honecker, do you have any redirect?
Mr. Roy may kill me, but yes, I do actually have a few. You've been up there a while. Do you recall, and I believe it may have been Ms. Frederick's very first question, where she asked them about O&M, and that costs have been going up in O&M?
Yes.
And I believe she gave you a number that you might have been a little bit confused with the number.
Yes.
Not talking about the number, can you tell us can you discuss any of the items that are included in that O&M expense going up?
Yes, so like I mentioned at the time I answered, I'm not sure of that number and what all goes into that. What I can say is on the settlement arrangement that we reached with the intervening parties, the two pieces that I'm aware of that I'm testifying on behalf of, there's Crossbore and there's Picaro, both of which are O&M and both of which are included. And I think Crossbore is $840,000 or so a year, and Picaro is around $300,000, give or take. Those costs I'm aware of. Again, I don't know how they fold into that other number.
Okay. And is there any other witnesses that may be able to provide some more detail on other projects that may be included in that?
Yeah, some other items that could be involved in that have to do with some things that we're doing safety-wise that witness Monty would be aware of, and also some things from an IT perspective that witness Rosa would also be able to address.
Okay. And then, do you recall getting some questions, I think they came from the vice chairman, about SMRP, AMRP, and those initial filings and what kind of went into those and the intent of those initial AMRP filings?
Yeah, so you're talking about when the AMRP was first developed and what the intent was there?
Yes. Do you know if there's another witness who might have been involved in that and be able to answer those questions?
Yeah, Columbia witness Cooper, I believe, was in regulatory for Columbia at that point in time, and witness Cooper, Judy would likely be able to respond better than I did on that
Okay.
question.
And then, I believe it was Ms. Frederick that referred you to staff data request 3, number 2, and there was a table about the leaks for 18, 19, and 20. Do you recall that as well?
I do.
And is that table, does that only include grade 1 leaks?
That table does only include grade 1 leaks. And when I was looking at it, something looked a little off to me on what we were talking about because the discrepancy was being made between the volumes. Grade 1 leaks are leaks that we have to address immediately. And when we grade it, grade 1, grade 2 plus, grade 2, and grade 3. So the point of that discussion was equating the level of leakage to bare steel to first generation plastic. And the reality is that first generation plastic rarely results in grade 1 leaks. They're not catastrophic failures that often have those types of issues. They're normally a lesser grade. So there wouldn't be, I didn't see it because I didn't see the page 1 at the time, but I thought there was something a little strange about it. So when I went back and looked, if you add the other gradings together, more than likely you're going to have a little bit different image or picture of what that looks like in comparison.
So there are other leaks other than just grade 1 leaks that would
Absolutely.
affect the first generation plastic?
Yeah, at each level you're going to go up. So you're going to have, grade 1 is most severe, grade 3 is the most basic, and really not that big of a risk at all.
Okay, and then I think this is my last question. When you were discussing the line DE, ILI information, and you were talking about Georgetown in particular being a growing area where there'll be more, gas consumption, are you aware of any impending growth that's coming that may increase the consumption?
I think the one that I know the most is Toyota just made an announcement, and that's, adjacent or inclusive of Georgetown, I believe. I don't know where the lines go for that, but in that region, that's the biggest one that just got announced and one that we're working on to ensure, that things go well. But there's also where the station is that feeds Georgetown. I'm blanking on the kind of the bypass of the road that goes around, but I know that there's some development parks in the area that we are serving, and whether those are opportunistic for the state, I'm not sure.
Okay. All right, I have nothing further.
Is there a reason that Mr. Roy can't be excused for the remainder of the hearing?
Mr. Chairman, can I ask just 1 or 2 follow-up questions?
Sure.
Thank you. Good afternoon, Mr. Roy.
Good afternoon.
I just wanted to follow up on sort of one loose end in my mind. You were discussing with the chairman the 2020 requirements and how prior to those requirements you haven't had to do the pressure testing. Is that correct?
That's correct.
If there was no ILI, when would the DE line be due for pressure testing?
So there's 2 different factors there. There is an HCA. The HCAs have varying points in time that they've got to be pressure tested because in the 7-year period and 7-year cycle, we assess them at each of those HCAs at different points in time. And with the new MCAs, those have to be done in the next 14 years. So overall, we would have to be pressure testing those 17 locations. We'd probably spread them out because to do them all at once, you'd be taken down. It'd be impossible to carry the system, even partially. So I would say over the next 14 years, we would have twice on HCAs, most likely, and once on all the MCAs. So you do 10 plus the 12, so you do 22 times that you'd probably take some stuff down. Does that get to your question?
Yeah, I think so. So specifically for the Toyota facility, would do you know if that would require that facility to come down?
Yeah, specifically, so from an HCA perspective, now that we've got to include pressure testing, HCA's wouldn't have required Toyota to go down. I think we could have managed that without it. It'd be iffy. And I don't know about the expansion because we haven't modeled that expansion yet that Toyota is doing. With the MCA's, yes, because the HCA is just due east of the plant, and we think we could cover part of the load, but the MCA is, I think, is it Cherry Blossom that's on the north side there of the plant? Our station's there, and the MCA wraps itself around the interstate and some other areas. So I don't know that there's any way that we couldn't get out of a decent sized outage for Toyota. We'd have to plan and work together on that.
Thank you. Those are all the questions I had.
Tonica, any redirect?
No, you're.
Thank you very much for being here with us today, Mr. Roy.
Thank you.
Ms. Honecker, we're going to take a short recess and for, let's say, 11-minute recess until 3:35.
And can Mr. Roy be excused?
He may be.
Okay, thank you.
Thank you.
All right.
Let it load. Not yet.
Mr. Cook, are you with us?
Oops. You're on now, Chairman.
Mr. Cook, are you there?
Yes, sir.
All right, great. Before we get started, so we're back on the record in case number 2021-00183, base rate case of Columbia Gas, Kentucky. Before I ask for your next witness, Ms. Honecker, I think it's yours. Yes. We have reviewed the questions that we've asked to date, and the information, both council and the commissioners, the information we've received from those questions. We've identified, unless other council has an objection or the company would like to call the witness for any reason, I've identified a number of witnesses we don't think would be necessary to call through the remainder of the hearing. Those witnesses are David Monte, Michael Rosa, John Spanos, Melissa Bartos, Kevin Johnson, and then the Attorney General's witness, Mr. Dittemore. Does counsel for the applicant have any objection to excusing those witnesses from the remainder of the hearing?
No.
And how about for KIUC?
No objection, Your Honor.
Mr. Cook, do you have any objection to excusing those witnesses from the remainder of the hearing?
No objection, Your Honor.
Staff counsel?
No objection, Your Honor.
Okay. So as I understand, Ms. Honecker, that would leave us with questions for Judy Sigler, excuse me, and recalling Ms. Cooper. Is that your understanding as well?
Yes.
Okay. All right, with that being the case, we won't put anything in the record on it, but we will excuse for the remainder of the hearing David Monte, Michael Rosa, John Spanos, Melissa Bartos, Kevin Johnson, and the Attorney General's witness, David Dittemore.
And I know Melissa Bartos is on virtually, so I hope she heard that.
She had the rest of her day. Well, with that being the case, Ms. Honecker, I guess call your last witness that you don't plan on recalling.
Judy Sigler.
All right, Ms. Sigler, if you don't mind to remove your mask for this purpose, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
My name is Judith L. Sigler. My address is 801 East 86th Avenue, Maryville, Indiana, 46410.
All right, Ms. Honecker, you may ask.
Can you state your title for me and who you're employed by?
I'm a lead analyst, lead regulatory analyst. I'm employed with NiSource Corporate Services, Business Unit 12.
And are you the same Judy Sigler that filed testimony and responses to data requests in this proceeding?
Yes, I am.
And do you have any additions, corrections, anything to make to those?
No, I don't.
If I were to ask you those same questions today, would your answers be the same?
Yes.
Is it your desire and intent to incorporate those documents into the record of this proceeding?
Yes.
Did you bring any materials with you to the witness stand?
Yes, I have. I brought my direct testimony, my data requests, and a couple notes.
Okay. The witness is available for cross.
Okay, Mr. Cook, do you have any questions for Ms. Sigler?
No questions, Your Honor.
No questions,
Mr.
Your Honor.
Bain, excuse me. Ms. Frederick, any questions?
Yes, Your Honor, thank you. Now, we're going to be generally referring to Columbia, Kentucky's responses to staff's first request for information, items 52 and 53. And then also Columbia, Kentucky's response to staff's second request, item 47. All right, just so, and we can go back to that if we need to.
Okay.
Can you explain why the amount for operating matching order, operating flow order demand penalty was 0 in calendar year 2020?
And this is on 52?
Yes. 52 and 53.
At this time, no, I cannot answer that. I would have to look into it.
Okay, I will just send you that as a post-hearing data request.
Okay.
And for forfeited discounts, return check charges, and reconnection charges, why did Columbia, Kentucky use a 3-year average when the actual charges for those items in 2020 was significantly lower than the 3-year average?
We've did it over across the board, doing a 3-year average with all the costs.
Is that just the way you would have normally done this anyway? You would normally look at 3 years in preparing for this rate case?
For this rate case, that's what we decided to do, was a 3-year average.
3-year average?
Mhm.
And just to let you also know about another post-hearing data request, staff is going to be requesting separately by year from 2016 to now, the number of reconnections that have been attributed to customers who were disconnected for non-payment of bills or violation of rules, residential customers who request disconnection for which the customer is reconnected within 8 months, and commercial customers who request disconnection for which the customer is reconnected within 8 months. That'll just be coming your way in a post-hearing data request. I'm just looking over my notes and making sure that I have covered everything. I think that's it. Thank you.
Vice Chair, do you have any questions?
No questions.
Commissioner Butler?
No questions.
I have no questions. Do you have any redirect, Ms. Honecker?
I do not.
Thank you very much for being here. You may be
Thank you.
excused. All right, and I guess we can either recall her or you can, Mr. Sanford. But if you'd like to recall Ms. Cooper, now would be a good time.
Sure. I would like to recall Ms. Judy Cooper.
All right, Ms. Cooper, you may
Can
have
I
a
do
seat.
that? Okay, sorry.
You remain under oath from earlier.
Okay.
And I guess I'll give you an opportunity, Mr. Sanford, if you want to narrow
Sure.
any of the questions.
Yeah.
It's your witness to recall. You asked to do it, and I don't think we have an objection to it.
Okay, I appreciate that. I think there was maybe a couple of, or at least one subject matter that was referred back to her, so I'll probably try to get some questions there.
Please proceed.
Ms. Cooper, do you happen to recall, I think there's been some discussion about the ILI project for Line DE. Have you heard some of that testimony today?
Yes.
Okay, and I think there were some questions earlier about why the company had not requested a CPCN from the commission for that. Do you recall those questions?
Yes.
Okay, and so help me understand a little bit you've been involved in rates and regulatory department for some period of time, correct?
Yes.
Approximately how many years?
Approximately 39.
And so you started with the company when you were 7, right?
That's correct. In dog years. Just teasing.
So in your experience, is it fair to say that part of the purpose of the CPCN is to determine what alternatives may be available to a proposed course of action or proposed investment?
Sure.
Okay. And you heard what Mr. Roy testified to earlier with regard to options with regard to Line DE?
Yes.
Okay. When we're talking about whether something is in an ordinary course or is an ordinary extension assist in an ordinary course of business, has the company had any other cases in recent years that have involved that question?
Yes, we have.
Can you tell us about that? And first off, if you could identify that case, but then just tell us a little bit about it.
Yes. I think the case number was 2019-00257. It involved a request to change our AMRP program in our projects for the 2019 project year. And the reason that we needed to make a change in our list of approved projects from what had been approved in our application in case number 2018 for, I don't remember what that number was, but according to the normal schedule, we filed the projects in mid-October for the upcoming calendar year. And so we had done that for 2019. But then we were in a situation where we needed to make some improvements to our low-pressure systems. Those improvements we had undertaken in 2019. They were not part of our AMRP work that had been requested in 2018. It was just work that we were doing on our low-pressure systems in 2019. And we were humming along, and an order from a peer utility came out from the commission. And in that order, there was a statement that made us pause our work on our low pressure improvements, because it seemed to indicate that we might need a certificate of public convenience and necessity for the low pressure work that we were doing. And that order, the way we read it, said that if the project was 2% of the utility's net utility plant, that a certificate of public convenience and necessity was required. Our low pressure system improvements was about, I think, about a little over $11 million project, and which for us was a little over 3% of our net utility plant. And when we saw that order that said 2%, we paused our low pressure work, made an application in the case number 2019-00257, requesting a certificate of public convenience and necessity if the commission deemed one was needed, or in the alternative then allowing the modification of our 2019 and expected 2020 work plan to include the completion of our low pressure work. So that's when the CPCN determination came to light.
Okay, so that case, the order came out in the 2019 timeframe?
Yes.
And approximately when was the company considering whether or not a CPCN might be required for the ILI system?
So the ILI system would have been shortly thereafter, maybe actually very close in the fall of 2019, because this is 2021. So we filed our work plan for 2021 in the fall of 2020. That order had come out in the fall of, I think it was 2019. And the order, when it came out, said that 2% of net utility plant was not a bright line or a solid line of demarcation that determined when a certificate of public convenience and necessity was required. It said that each project should be evaluated on an individual basis to determine if a certificate of public convenience and necessity was required. And if the project was in the ordinary course of business, then no certificate would be required. And at that time, the low pressure work, as I said, was, I think, 3.28% of net utility plant, and the commission said that was in the ordinary course of business. When we looked at our ILI project, we put $10 million in our original request for our SMRP work in 2020. That $10 million would have been less than 3%, I think about 2.8% of our net utility plant. And we determined that it was work being done to meet PHMSA requirements, and it was in the ordinary course of business. It did not duplicate any existing facilities. It did not infringe upon the utility services of another utility, and therefore we determined a CPCN was not required.
Okay, so in the questions that were asked of Mr. Gore and Mr. Roy today, I believe that it was couched in comparison to the percentage of the capital expenditure budget. Did I hear that correctly?
I did hear a reference to the capital budget, but the order says net utility plant.
Okay, that you anticipated my next question
Oh,
based
sorry.
upon, that's okay, based upon your experience starting when you were 7. Has the commission typically just or adjudicated whether or not something is in the ordinary course based upon the net plant or a capital budget?
Net plant.
Thank you, Your Honor. No further questions.
Mr. Cook, do you have any additional questions?
No, no questions, Your Honor.
Okay.
No, Your Honor.
Ms. Frederick?
No further questions, John.
Vice Chair, any questions?
No questions?
Commissioner Butler?
No questions.
I have no questions. So you don't get to redirect. Mr. Sanford? Thank you very much, Ms. Cooper.
Thank you.
You may be excused. At times commonly referred to as the admonishments, Mr. Sanford. I always take the opportunity to admonish you whenever I can. I don't get the opportunity as much as Mr. Bain. Let's see here. I want to make sure that there's nothing else that I have written down that I need to address before we move along.
Mr. Chairman?
Go ahead.
You may want to explain the process. Mr. Clark has not had the privilege of being admonished yet, so you may want to clue him in on what we're about to do.
And I can explain the process and you can tell them the stories. How about that? All right. Before we move on, as my understanding, we only have a single exhibit, and you have moved for the introduction of that exhibit. Is that correct, Mr. Sanford?
Yes.
All right. So we have the single Columbia hearing exhibit 1. Candace, it's the only hearing exhibit we'll have. We'll go ahead and try to get a little bit of the scheduling out of the way before we move along.
Sure.
It's my understanding that the the suspension date in this case is December the 29th, 2021, which would put the statutory date, I guess, in April, maybe. We have a number, the commission and commission staff have a number of post-hearing data requests. We have an anticipation that those can go out this Friday, November the 5th. If they go out Friday, November the 5th, I believe they're all to the applicant, Mr. Sanford. How about responses due on Friday, November the 19th? We'll give you 2 full weeks to respond.
That would be wonderful. Thank you, sir.
We'll venture to get those out. Does Columbia anticipate filing any briefs in this matter?
We'd like to have the opportunity to. I don't know that it'll be a lengthy brief, and we won't need a reply. Just one brief would be sufficient.
So I'll tell you what we'll do. We'll set the opportunity for any party to this case to file simultaneous briefs on November the 23rd should a party choose to do so, we'll just go with, I'm sorry, not the 23rd. Monday, November 22nd. Should any party choose to do so, we'll give an opportunity for simultaneous response briefs that Friday, November the 26th. And at that point, unless there's additional follow-up through discovery by commission staff, we'll submit the case on. The case will be submitted for decision 12/01 the 27th. So, Mr. Clark, I'm not going to explain the story to you, so you will have to let Mr. Sanford do that. As a result of a number of concerns regarding settlements over the years, the commission asks any party, any participant in settlement agreements, to swear to a number of statements, primarily assuring that the agreement that was filed is, as it says, the entire agreement. There are no additional agreements, certainly not those that include things outside of the commission's jurisdiction or purview. So I'll ask a number of questions that effectively you will answer under oath or verification with your hand raised, and you'll answer those in the affirmative or in the negative, depending on what the question asks. Mr. Payne, this is not your first rodeo, is that my understanding?
I've done this before, Your Honor.
Mr. Cook, are you there?
Yes, sir.
We're not going to leave you out. I just ask that you turn your camera on and raise your right hand with everybody else, as well as your microphone. So please stand and raise your right hand. Were you aware of and did you have an opportunity to participate in all of the negotiations that resulted in the settlement agreement?
Yes. Yes.
Did you voluntarily sign the settlement agreement, and do you fully support each and every provision contained therein?
Yes. Yes.
Are there any provisions in the settlement agreement that you do not understand, object to, or take issue with?
No.
Was any consideration of any kind offered, or were any promises made other than what is expressly set forth in the stipulation to induce you to negotiate and sign the document?
No.
Are you aware of any reason why the commission should not adopt and approve the stipulation in its entirety?
No. No.
Thank you. Other than the applicant's, 4 o'clock. Other than the applicant's outstanding motions for confidentiality, are there any other matters that the commission needs to take up in this matter?
Not aware of anything, Your Honor.
Nor am I.
Not hearing anything else, we will adjourn. Thank you.
Thank you.
Thank you.